All rise. All persons having business before the Honorable Associate Judges now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first is DC Health Registrar of Vital Records versus Mike Parker. Counsel, if you could introduce yourself for the record, counsel for appellant, and let us know how much time you would like for rebuttal.
Good morning, Your Honors. Dia Roshinariu for the District of Columbia Department of Health Registrar of Vital Records. I would like to reserve 5 minutes for rebuttal.
Great. And counsel for appellee, you can take your seat if that's all right. Thanks. Whenever you're ready.
Good morning, Your Honors. This case goes to the heart of DC Health's ability to ensure the accuracy and validity of vital records, a role it takes seriously given the risk of these records being used to commit fraud, identity theft, or other crimes. There are 3 independently sufficient reasons for reversal here. First, and most importantly, as it is undisputed that Mr. Parker failed to adequately serve the Department of Health or the mayor or the Attorney General under Rule 4J. The July 2020.
Can I stop you right there? So your argument that there was a failure of service seems premised on the fact that the agency is a party, is a defendant. And I'm wondering where that understanding comes from under the statute. Under 7-231-16.
Yes, so DC Code Section 7-231. Well, let's go. We'll go back to 7-231.11, which says that if the DC registrar denies the petition, it shall inform the petitioner of their right to bring a cause of action in court. And then 231.16 says that the petitioner may bring a complaint. So these words, cause of action and complaint, typically involve adversarial.
Well, it also says, sorry to interrupt, but it says if an application to register a record is denied, the applicant may file a complaint. And then it says the court shall provide notice of the proceeding to the registrar. It's very odd if the registrar is a party, why the court would have to provide a party notice. That's unusual. And then it says a petition filed under this section shall be governed by the rules of this court. So it talks about a complaint, then it talks about a petition, and it also talks about this unusual notice provision, which seems oddly redundant or unnecessary or just unusual in a case where you already have a named defendant. So I'm trying to figure out how to work through that language.
Here is a little unusual. I think at the heart, this case.
Well, I'm just wondering, what does the government look to under the statute to say, hey, we're a party to this action? The agency is a party. What text should I look at to say, oh, well, of course they're a party, so of course Rule 4 applies?
And the text in the statute is the cause of action and the complaint, but I think it also makes sense to step back and take a look at the remedy here. So at base,
I'm sorry, just to break it down, just because you have a cause of action, that doesn't define who the defendant is to the cause of action. And why is the defendant the agency? I mean, it's not obvious to me under the text of the statute. If you think of the registrar as sort of the librarian of records, and they're just keeping the records, and they, people ask, oh, hey, can I have a new birth certificate? And they look to see, okay, do you have the required documents? Yes, 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 or no, no, no. But then you have a right to go to court separate and apart from being able to submit these documents to the registrar and say, hey, I don't have those documents, but let me prove that I'm a citizen, that I was born in the district. these other ways. Why does the registrar have a dog in that fight, I guess?
Well, at base, the remedy that's being requested is an order requiring a DC agency to do something. In such cases are typically either declaratory actions or they're seeking injunctive relief. And those cases sound in civil law or in equity, and they're adversarial in nature. So any other case where someone would be asking a DC court to issue an order ordering a DC agency to do something would be one where the DC agency is a part, or the District of Columbia is a party.
Well, that's again on the assumption that this is an independent lawsuit. If it's a petition, and the word petition, petition for agency review, then the procedures are a little bit different. And they're governed, at least in part, by Superior Court Agency Rule 1 that talk about petitions for agency review and how you challenge agency action. I take it you think that Superior Court Agency Rule 1 is not the applicable set of procedural provisions that govern how this should have proceeded in the trial court.
That's correct, Your Honor. And that's for similar reasons. It's called a cause of action, it's called a complaint, but most importantly.
So just to be clear, so you think that this is like an independent lawsuit. So the next thing that should happen in your view, if assume for a moment service was properly affected and there wasn't a timing issue with that. So just assume in a normal case, let's say what should happen is service, and then there would be an answer, and then there would be discovery, and then there would be the full panoply of de novo proceedings relating to an independent action. Is that your sense of what then would happen?
Yes, Your Honor. And I think that the court can set, procedures to expedite it. But yes, it would be that the regular rules of civil procedure would be followed. And that's because this isn't one of the petitions or other documents that fall under, any of the other types of rules of the court. That there isn't.
Contrary to the SOPs of the agency, which seem to contemplate some sort of, I misplaced them right now, but some sort of show cause proceeding. I mean, I think that the SOPs talk about the agency appearing as a possible witness, or talk about the Office of the Attorney General getting involved after an order is issued and asking for reconsideration, or, somehow responding to an order to show cause. So that doesn't seem to be your understanding of how this works, your response to Judge McLeese, that there's going to be a complaint and then an answer and then discovery, doesn't seem to mesh with the standard operating procedures that the agency itself has drafted, which obviously are not binding, but reflect how the agency perceives its role.
And I'm sorry, Your Honor, I'm not familiar with the SOPs that were in effect at the time that Mr. Parker filed his petition.
Okay.
My understanding is that the statute that we're dealing with here is based on a model statute. Is there anything in that model statute or its legislative history, to the extent there is one, or in how other jurisdictions have applied similar statutes, that explains to us what it means for a petition to be governed by rules of court? It's an odd sentence.
So that sentence does not appeal in the model statute.
I see.
Okay, so that part was added by the DC Council when it first enacted.
I'm sorry, which exact sentence are you talking about now? I just want to make sure.
So these proceedings will be governed by the rules of the court.
Do you know if the words like complaint and action in court, some of the other terms?
Also, the word complaint does not appeal in the model rule as well.
But the model statute talks about the state registrar appearing and testifying as a witness.
Yes, that's right, which does not appear in the District of Columbia statute. And different courts, to answer Your Honor's questions, different states have applied the model rules in different ways. Like, for example, some actually do treat it as an action under the APA and as an appeal. Here, we don't have that because the trial court is empowered to take additional evidence. And so that's why we wouldn't consider this an agency action. The trial court can consider evidence beyond what was submitted to the registrar.
Can I ask you, I just want to get back to you in making the argument that we should understand the proceeding that is contemplated here to be an independent lawsuit rather than a petition for agency review. You were focused in part on the language in 2311, which refers to an action in court. And are you implying that in your view, a petition for agency review is not an action in court? Because it just doesn't seem obvious to me that action in court tells you which, whether it's a independent lawsuit action in court or a petition for agency review action in court. And now maybe action in court is clearly understood to mean one rather than the other. It's just not obvious to me off the top of my head that that's true.
No, Your Honor, I was thinking of that more in line of whether the Department of Health was a party at all, or the district was a party at all, or whether we should instead think of this as an ex parte proceeding, which
Well, not
I
an
suppose
ex
would also
parte
be an
proceeding,
action
but
court.
just a proceeding in which the registrar can show up as a witness, may be called as a witness by the court. And certainly has, is entitled to notice under the statute that the proceeding is happening and that the proceeding has concluded with an order. Right? I mean, that's not ex parte necessarily. It's just there's a statutory cause of action that just doesn't envision the registrar being a defendant.
I mean, I do think that, using the word complaint and saying that the rules of the court will apply, which is not in the model rules, counsel towards that interpretation. However, even if you say.
But even if you're looking at the nature of the proceeding isn't, I mean, I guess it could be, look, I satisfied all the requirements in the DCMR and the registrar denied my application anyway, and so reverse them. But that doesn't seem what the essence of 7-231-16 is about, right? That the statute for going to court, having this action is to say, look, I concede that I can't satisfy the DCMR requirements set forth by the registrar. I'd like to do it a different way. I'd like to have a hearing where my credibility and the credibility of other witnesses are tested or scrutinized or examined. And then I'd like the court to make a ruling on my place of birth, separate and apart from this sort of, bean counting. Let's look at documents. Do you satisfy the actual documents? So in that world, if you envision this proceeding that way, why would the registrar be a defendant? They don't have anything to defend. They're not capable of making those credibility assessments, right? That's what you go to court for. So it's not computing for me why you're thinking that the registrar has to be a party to this case.
It would be
Certainly has to have notice under the statute.
Yeah. It
Could
would
be a
the same-
witness,
yeah.
but that's what's confusing me.
I mean, this isn't really unique to this statute in this case. So I do want to analogize a little bit to like 8 USC 1503, which is the federal statute that allows one to bring a declaratory action against the United States if they're denied one of the benefits of being a United States national. And that is considered an adversary proceeding. Notice is given to the Attorney General and the U.S. Attorney for the district where the action is brought. And then the United States government can introduce the evidence that it has for whatever reason it's denied, issuing a passport or issuing or denying any other, like a social security card or social security number. And, those are framed as adversarial proceedings.
Did you cite this federal code provision in your brief? Was this discussed in your brief?
We talked about, how in other contexts courts consider delayed like registrations of birth and foreign birth certificates. It's cited in that context. It's not cited for the specific proposition. And I'm not arguing, Your Honor, that is a binding interpretation. That's a different statutory scheme. It specifically says you can file a declaratory action. I'm just bringing it up to say that it's not unusual to think that that the state or an agency would have an interest in something like a declaratory judgment to show that someone is a citizen or is born in a specific place.
A couple of the questions have suggested that DC Health's role as registrar is as a librarian of records, or that it's just a bean counter. I want to ask you about that. I mean, do you think that the agency has a role here in explaining the rationale for some of the documentation requirements, or is its role more as a bean counter or a custodian of records? Yeah, we said you needed 1, 2, 3, and 4, and you either gave us all of them or you didn't. Or is it more the ability to tell the court, for example, the reason we need number 3 and can't accept some other alternative is this? What would you say to that?
Yes, Your Honor. So 7231.08G specifically says that the registrar is the entity that is delegated the authority to determine what the evidentiary requirements are to meet, to show that someone is born in the District of Columbia. And then one of the requirements in 231.11 is that the registrar give a detailed list of reasons. And this is because they have expertise in the types of documents that are more likely to be probative of whether someone is born in the District of Columbia or not. And even if, you don't say that the court is like bound by their regulations, that would still,
Well, clearly they're not. Right? I mean, the agency promulgates regulations for how the agency is going to operate,
so 231.
right? And then 7231.16 says you can file this petition for registration of live birth or delayed registration of live birth. And you have to give the court the materials that were generated by the registrar, but you can present any other information needed to establish the facts of a live birth in the district, right? So that's a foundation, but the statute says go beyond, right? Like if all the necessary documents are, burned up in a fire, or that's my allegation, and I just don't have them, but I can bring, the doctor who miraculously, was there when my mother gave birth, and I can bring, the minister who came and, baptized me, 2 days later at my house. And I can, bring all these witnesses to court to say, yeah, we were here in the District of Columbia. She was born here in the District of Columbia. It seems like that's what the statute says the court can rely on, even if none of the documents that the registrar has said in the DCMR are required for the registrar to issue a certificate are available.
So 231.08G does say that the registrar shall determine the evidence that shall be required to establish facts of live birth. So there is also some statutory.
So then are you saying then that the registrar makes the final call and that this court proceeding has no utility at all? I mean, clearly, yes, the registrar gets to decide what the regulations are for the registrar, but are you saying that the registrar's regulations then bind the court? And so the court's only role is to make sure that the registrar did its job correctly?
No, Your Honor, we're not saying that the court has to rely on the registrar's determination. So the court is free to reweigh the evidence, is free to consider additional evidence, including the background check that is required by the statute, and come to its own independent determination. What we're simply saying is that the registrar's regulations set a minimum bar for the records.
But what about my hypothetical, right? All of the documents are gone, or so I say. But I bring in, 10 different witnesses, very credible witnesses, to say she was born in the district.
I mean, I think that there.
Can a court under 7231.16 then order the registrar to issue a certificate of delayed birth?
So we think that there's a reasonable argument for that interpretation.
It's a yes or no question.
I mean, yes, I would think that there are like exceptions in extraordinary cases, Your Honor.
Why is that what's the exception for extraordinary? I mean, it just seems like the statute says that's exactly what's contemplated.
But it's not like out of the realm for a statute to delegate to an agency to create like substantive rules that the court will then apply. And we're simply arguing that that's what happened in this case. But we don't think that, if the court doesn't agree with that, we don't. That is not like the only basis for reversal in this case. And we think that there,
Before you move on, I
Yes.
do want to just follow up with one thing, at least for me, I don't know about my colleagues. I'm interested. You mentioned that I thought I understood you to mention that you're aware that there are cases in other jurisdictions applying variations of the model statute that our statute is also a variation of, that have treated the proceeding that is contemplated in court to review what a health official determination, or at least to make a I don't mean to imply anything by the word review there, that some of them have treated that as APA style review. I looked for cases along those lines. I found one from Oregon that seemed to go the other way in a divided court, but I myself would be interested in like a 28K letter where you would advise the court of the authority you found on that topic. It seems to be potentially relevant to some of the things we're trying to fight through. So
Yes, and that's the case that I was referring to, Your Honor. And the Oregon statute is different because it specifically used to have a provision there that said like APA review will apply to this section. And then it like took away that section later, and that's what the court was trying to
Okay.
interpret.
Oh, I thought you said you thought that there were jurisdictions that treated it as APA style review. I thought the Oregon court said, no, this is an independent action, not APA style review. That a majority of the court said that. That's what I recall.
Oh, it did after it amended the statute, Your Honor. I don't want to
you're
get
saying
into the weeds. It had a previous version of the
I see.
statute that applied to APA.
I see. I understand. Thank you.
But yes, Your Honor, if
So just to be clear, if the only case you're aware of is the Oregon case,
yes.
then don't feel free not to file a 28K letter because I'm aware of that case.
Even if the court says that the registrar is not bound by the regulations, we would say this still should give weight to the regulations because they inform the court of the types of documents that are probative.
Did Mr. Parker eventually give to the court everything that he gave to the agency? There was something in the briefs about how initially he didn't.
Yes, Your Honor, that's not one of the bases for reversal in this case. And then again, look, even if this isn't a civil proceeding and Rule 4 doesn't apply, and we look just at the statute, so Section 7231.16a, that does require the court to give notice to the registrar, and it's undisputed in this case that the court never gave notice to the registrar before the hearing or before issuing its order.
I ask you if it's not an independent action, I keep wrapping back around to that, for which I apologize, but it seems like it would be subject to the agency review rules, and that does have its own service requirements. It sends you off to Rule 5 rather than Rule 4. Is that something you've worked your way through, and do you have any sense of how those would apply here or would not apply?
No, I'm sorry, Anna, and that's not something that was considered or brought up below. So it's not like a base, hasn't been an issue in this appeal. I would like to go very quickly to the Rule 60b-6 basis for reversal. The major one, which is that the Superior Court never applied or considered the Starling factors. And that in and of itself is reversible error because failure to consider the legal basis for reversal is an abuse of discretion. And then when you look at the Starling factors.
Well, that would just get you a remand then back to the Superior Court to consider them. What is there a reason that we would consider them in the first instance, assuming that you're a party that can raise a 60b-6 argument? Is there a reason that we should go beyond and actually consider the Starling factors in the first instance here?
I mean, they do weigh rather heavily in favor of the district, especially the Superior Court's failure to conduct a background check, which is a prerequisite of even issuing any findings. But Your Honor, we would be happy with a remand order, remanding it back to the Superior Court to consider the Starling factors.
It struck me as quite odd that the judge who decided the reconsideration motion is the spouse of the judge who issued the earlier ruling, and I don't think anybody really complained about that.
Yeah, that hasn't been an issue.
It's not been an issue.
That has not been an issue in this
So
appeal.
a
Not-
remand to that same judge would be satisfactory?
I think that I don't know how the court typically remands, whether it remands to the same judge or remands to a different judge. It wasn't an argument that this DC.
I think
Health
we
made.
usually remand to the Superior Court, and the Superior Court then generally sends it back to the same judge unless we say, please assign a new judge. But there's been no argument here.
Yeah, I mean, given the court's
That this-
failure to
The
completely.
judge in the Rule 60B proceeding who even noted, oh, my husband ruled on this initially. And no one said anything.
I mean, again, yeah, that's not an argument that the DC House made below, but I mean, given the court's failure to even consider the Starling factors at all or mention them or cite them in the order, we would obviously support remanding to a different judge who would consider the factors as directed by the court. And if the court has no further questions, we would urge the court to reverse and remand. Thank you.
We'll give you a few minutes on rebuttal. Thank you.
Thank you, Your Honors. Keep my brief, but,
Counsel, can you come to the podium so we can hear you through the microphone? Thank you.
So briefly, regarding the background check, perhaps I was creating difficulties where none exist, but it seemed to me that statute said the court will order it. So I didn't say my client should go somewhere and get a background check
But the
of some
court-
nature.
The court didn't order it,
That's true. The court
right?
didn't.
And that's a prerequisite, right?
Yes.
For the court issuing an order. So
Yes.
how can the court's order stand in light of the fact that the court didn't order a statutorily required background check?
Well, Your Honor, my client be glad to get a background check as ordered by this court or accept a remand with instructions to order the background check and he'll get it.
Well, I guess let me be more pointed. How could we just remand? I think we would have to vacate the order because there's been no background check.
Well, remand with instructions that there need not be an entire
Well, that wasn't,
hearing.
that wasn't the only provision of the statute that the court, I mean, be curious to hear what you think the DC Health role is in this proceeding, but set to the side for a second, the statute says the court has to provide the agency notice of the proceeding at the outset, right? The court has to order a background check and the court has to give notice of the final order
Mhm.
to the agency. None of those things happened in this case. So how can we let this order stand? Whatever the agency's role is, it seems like they were entitled to notice, and then with that notice, they could have made the arguments that they were a party, that they were a defendant, that they were entitled to, answer the complaint, to, make discovery requests,
Well,
however they wanted to litigate it, but they weren't able to do that because the statutory notice wasn't provided. Why don't we have to unravel all of this?
well, Your Honor, I don't know why the court didn't give them notice, but I gave them notice and, it's not disputed
But
that.
you
it was
you
received.
can't fulfill the court's statutory obligations.
Well,
Can you?
No, I'm not suggesting well, in the sense of notice, notice is notice. It was sent. Nobody suggests it was not received, just that.
To be clear, that was a notice at the front end. Did anybody give notice at the back end of the order? At some point, I guess, obviously, because
Yeah.
at some point they became aware of it. That was not promptly done though, right? Or was it?
Yeah, well, as soon as the court entered an order, my client went down there and asked for, his delayed birth certificate and was told he was going to get it, but did not.
You say as soon as I don't remember the timing. Do you mean like literally the next day or the same day or what do you
No, he
mean?
waited for a certified copy of the order to arrive through the mail. So
Right.
then,
So my understanding of the
A week or
timing
so.
is that the court issued its order on July 19th, 2022.
mhm,
And it sounds like the district is not contesting the representation that Mr. Parker provided a copy of the order to the agency on September 21st by handing it to an employee, didn't go to the office of the general counsel. So
That also seems untimely under the statute, even if your client could stand in for the court with respect to what the statute contemplates. 7-231-16H says that the court shall forward a copy to the registrar no later than the 10th day following the month in which the order was entered.
right. I think those time limits are so that the records can be, that can be entered in the records of the registrar and they can update the results of the case.
But so you would agree that in addition to the court not doing that, it was not done in a timely manner by anyone as required by the statute?
Well, my understanding, just from speaking to my client, is he did not wait a month and a half. He waited for a certified copy of the order and then presented it. Which would be, time for it to be certified by the clerk's office and mailed out. But I don't have a record that handy.
Did you want to express a view about the nature of the proceeding that you think is contemplated under the statute? I noticed that the case initiating document that you filed was called a petition.
Yes.
And it obviously wasn't served in the way that you would file an independent action. So I take from that you were conceiving of it as kind of a petition for agency review rather than an independent lawsuit.
Yes, that's correct, Your Honor. That's what I thought. It does say complaint in one place in that section, but it says petition several times thereafter. And the interest of the registrar is that it is in the preservation of the accurate records of vital events, birth, death, divorce, and so.
And I definitely get the idea that implicit in the way you handled the matter in the trial court, and I think implicit in the way you have argued some of the aspects of the case in front of us, is that you did not think of it as an independent lawsuit. You thought of it as a petition for review, calling for agency action. It's a separate question, I guess, whether, even if conceived of that way as a petition for review of agency action, whether the registrar, or if the registrar is not sui juris, whether the DC or some DC agency would be a party to that petition. I guess I hadn't understood you to argue that neither the registrar nor any other DC government agency is properly understood to have been a party to the proceeding that you initiated in the trial court. Did you make an argument like that in the trial court or in this court?
Yes, I did in my brief, Your Honor, I believe, that if Rule 4 applied and they were intended to be a defendant, that the statute could have said that much more clearly.
Well, I certainly took you to understand, to argue that you weren't required to serve the district under Rule 4. You definitely made that argument.
Right.
But the idea that, like, what is the registrar doing here? Like in the trial court, when there's a Rule 60B motion filed by, I'm not quite sure how it was captioned. I'd have to go look, but whether it was filed on behalf of the Department of Health, DC Health, or whether it was captioned for DC or the registrar, I just don't remember the argument that, well, who are these people? They're not a party. They shouldn't. Why are they here filing things as though they would have a basis for some kind of relief? I just don't remember that kind of argument in the trial court, and I didn't really pick that point up in your brief in this court.
Well, the petition did not name a defendant, and the argument we made is that if the statute contemplated the agency being a defendant, then there wouldn't be a provision that the court gives them notice, and there wouldn't be a provision of the proceeding, of the pendency of the proceeding. And that the court.
Yeah, I guess I'd understand that line of thinking as you were thinking of them as a respondent, not as a defendant, and therefore you didn't think they had to be served under Rule 4. I just didn't, I guess I hadn't picked up the idea that you thought they were pretty much a stranger to this litigation in the trial court and here. And they could have had a function as someone who was notified and might have tried to intervene but didn't, and could have been involved as a witness, but wasn't, in part maybe because court requirements about notice weren't followed. But I take it your position now is you think not a party. They are, the proceeding is contemplated as not only a petition for agency review rather than an independent action, but it is one in which the upshot of the proceeding will be an order to an agency, but the agency is not understood to be a party to the judicial proceeding that would result in that order.
Well, Your Honor, I concede I did not flesh that all out, but it
But
doesn't seem.
leaving aside fleshing it out, it seems like it'd be a pretty extraordinary court proceeding to say, go to court and persuade a court to order a government agency to do a thing, but the agency is not a party to that proceeding. That seems like that'd be quite unusual, and you'd want that to be pretty clearly indicated.
Well, except the statute in question is a model act that provides exactly that, I believe, and the idea that DC Council in providing a law that says, no, not that, this is regular adversarial litigation, did that by saying complaint once instead of petition, and by saying after it describes how the agency
Well,
gets
just to be
notified.
clear, I mean, there are two kinds of regular adversarial litigation arising out of agency action in the trial court. One of them is an independent action, you know, they used to be filed in equity before there was an Administrative Procedure Act or a DC Administrative Procedure Act. And that was like you file a complaint and there'd be full discovery, and that was fully adversarial.
Yes.
Then there is, you know, petitions for review under the Administrative Procedure Act or the DC Administrative Procedure Act, and those sometimes come directly to this court. They're adversarial as well. And when they're filed in the Superior Court, they're treated as adversarial ordinarily, in the sense that the agency or some governmental entity, sometimes there's a question about
Mhm.
whether it's DC as a whole or some part of DC or some DC official. But they're treated as parties ordinarily in those
Right.
kinds of actions. But I think the suggestion has been now that this might be a third kind of a thing, which is a judicial proceeding that's going to result in an order requiring a DC official to do a thing. But no DC entity should be understood to be a party to that proceeding. They get notice, but it's sort of, they're just not parties, and maybe they could try to intervene and become a party. Maybe they would be allowed to, maybe not, who knows? Maybe they would be a witness, but they're not parties. That's just a third thing I'm not very familiar with. Are you aware of other settings where there are judicial proceedings in court that end up as, you know, the remedy available is an order to a government entity, and the government entity is thought of as not a party?
No, I'm not, Your Honor, but it certainly seems like that's the way it was laid out. It's another level of review. You have a party who, a citizen who seeking a birth certificate and cannot get one from the registrar because there are prescribed rules to handle the vast run of cases. These are the kind of documents you need. And the employees at a registrar are not entitled to exercise discretion. Certainly appears under 723.11. And if you don't have those documents, you have to go to court and make your case to a judge. That doesn't seem like it should be an adversarial action. Nobody's suggesting that the register acted improperly on their denial. We accept that he didn't have those documents, and then.
So I
Mr.
guess
Parker,
it's a little puzzling to me whether the registrar does or doesn't have discretion in some sense of the terms. You're quite right that 2311A says to the registrar, you can't register a delayed report of
Right.
birth until evidence to substantiate the facts of live birth have been supplied to the registrar. And then D says if the applicant doesn't submit the minimum documentation, the registrar, that's one of the options. There are others as well.
Mhm.
The registrar shall not register the live birth. But
Right.
isn't it the registrar by regulation who sets what the documentation requirements are?
Right, the regulations are written. By
So
the
it's up to the registrar within reason to set what their documentation requirements are.
Right,
But once they've been set, the registrar, if they're not met, the registrar has to deny.
right, that certainly seems to,
And
and
here-
that's what happened in this case.
Right, and
The letter.
some of this wraps back around to whether this is an APA style proceeding and deference to an agency and what's in front of the agency matters, or whether it's a de novo proceeding, which might or might not have deference to an agency. But I guess I find myself a little puzzled about the respective functions of the registrar and the reviewing court. 7-231-11A does say generally, not just to the registrar, but it says generally, a delayed report of live birth shall not be registered until evidence to substantiate the facts of live birth has been supplied to the registrar. And then, so I mean, if the court later says, well, I understand that the registrar has authority to promulgate regulations, and somebody went to the registrar and said, registrar, register live birth and present nothing other than the applicant's own testimony, and the registrar says, that doesn't persuade me and it's not consistent with the regulations I have promulgated, so denied. And then goes to court and presents the exact same information to the court. And the court says, well, I've heard the person and I credit the testimony, and therefore I find that the person was born live in the district. On the one hand, it seems very much antithetical to a reasonable structure of like an agency process to allow that to happen. It seems a little bit, it seems in tension with the language in 11A. But on the other hand, it does seem as though perhaps that's contemplated by section 16, which does say, without qualification, if the court finds that the person has been, was born live in the district, then the person shall issue a delayed birth certificate. So I find, I guess, the provisions are pretty unclear about what the respective functions are and who is bound by what or not. I don't find them clear. Am I missing some clarity that I should be picking up?
Well, I think 723.11, and I think the practice is not that the registrar will consider and weigh testimony or even accept testimony. I mean, I think it contemplates it's going to be decided on the papers. What documents do you have? Do you have enough documents in the right categories that they're required to see before they register a delayed birth? And if you don't, they don't register it, and they inform you by their rejection letter that you can either come up with these documents or obtain an order of court.
As you were proceeding in Superior Court, what was your understanding of the language in 723.16 about a petition being governed by rules of court? Did you have something in mind there? I'm like Judge McLeese. Is there some interpretation here that would give us some clarity that we're missing? What did you think that meant?
Well, Your Honor, I filed a petition, just basically following the form, and it appeared, and I guess I expected that the court would give them notice and that they appear or not. I don't recall whether at the initial hearing I was thinking of them as witness or defendant, honestly.
But generally, what rules of court do you think the petition that you filed are governed by? Because I mean, the statute does say, after saying notice, so, the court shall provide notice of the proceedings of the registrar. The next sentence is a petition filed under this section shall be governed by the rules of the court.
Right.
What rules do you
Well,
think that means?
I thought it meant thereafter,
Well, I mean, but which rules? What, like,
civil procedure, the rule,
So you think the discovery rules and the whole panoply of the rules of civil procedure you think apply except for service, because you think service is kind of supplanted by court provided notice?
the previous sentence, yes. Yes. And
So
then,
you fully expected that the registrar would appear pursuant to the notice provided by the court, and then the registrar could do all the things, file an answer, request discovery.
well,
I mean,
Your Honor, appear or not appear, they're not named as a defendant. Nobody's accusing them of any misdeeds. They've done their job in this manner, and issued a rejection letter, and now citizen has access to the court to review that.
and just on the fact that you styled this as a petition for review, is that at all in tension with the fact that then when you appeared in Superior Court, you put your client on the stand and elicited testimony? And that doesn't sound like a petition for review. That sounds more like an original action.
As opposed to a review alleging there was some error.
Yes.
Well, I guess the caption did say that, but the text of the petition does not allege error by the registrar. We put him on the stand because the papers, the documents themselves that were available this 70 years later were not adequate to prove it. We had affidavits, but he also testified. Yes.
Can I ask you another possible rule that I would have thought you might have conceived as applicable, given your view that what you were filing was a petition, is Superior Court Agency Rule 1, which is, Superior Court review of agency orders or decisions. If you're right that the proceeding contemplated here is a petition, where you're seeking review by way of petition of an agency decision, then why wouldn't Rule 1 apply?
I confess I did not look into that.
And Rule 1 does say that the contents of a petition for review, it lists among other things you need to do is you need to state the names of the respondents, including the agency, which seems to suggest that if that's the rule that applies, you actually ought to have named, not as a defendant, but instead as a respondent,
Yes.
the agency, which would, I guess, be DC Health here, not the registrar. And then there are also some service requirements that are different from the service requirements in Rule 4. But you haven't really thought about the possibility that Superior Court Agency Rule 1 would have been the rules of court that would apply.
I have not.
But you do think that for essentially the similar reasons, to the extent that that contemplates service, the preceding sentence, which says notice, kind of supplants the requirement of service.
The preceding sentence of.
Of
16. 731.
Yeah, 731:16.
Yes.
And can you just what would be the practical reason why the legislature would say for this proceeding, normally we require that parties, I mean, I get the idea that if DC is not a party, and this is like a third kind of thing that I'm not very familiar with, then maybe notice would be enough and you really wouldn't need service. But assuming for a moment that a DC entity has to be a party here as a respondent or a defendant, what would be the logic of supplanting the ordinary service requirements with a notice requirement? Why would there be, is there some special reason why you would think that notice to the registrar, rather than, if you're thinking of it as an independent action, the very kind of specific special rules about how they want to make sure DC government entities get served, including, multiple people in DC to avoid what may have happened here? Or if you're thinking of it as an agency action, somewhat different procedures of service that go wrap back around to Superior Court Civil Rule 5. What would be the logic of thinking, notice is plenty here for this kind of an action rather than the service we ordinarily require?
Well, if they're a party, I can't think of a lot of distinction, why it should be different from Rule 4, maybe Rule 5. Initially, in drafting the petition and filing it, looking at the statute, the court's going to provide notice. That seems to supplant service process. Then when they intervene and file a motion.
See, and I guess that's where I don't, if the abstract idea is, there are rules that say, here's how a lawsuit is served.
Yes.
And if there was some provision somewhere that just says, oh, and by the way, the court is also going to give somebody notice, it wouldn't leap to my mind that the one would supplant the other. One might be a little superfluous, or kind of a belt and suspenders matter. And in particular, since service, it depending on who you think would have to have been served, it might be that the registrar would not have had to have been served, and it would be different DC entities would have to be served. And this would be a way of making sure that the actual decision maker also is aware of it. It just doesn't leap to my mind that a notice to one DC official would kind of obviously, well, of course, that supplants whatever service requirements otherwise would apply. It doesn't seem necessarily that would be a logical inference.
Well, looking back to earlier questions, is a DC agency being accused of an error? Is somebody going after the money of the District of Columbia or all that sorts of thing is where you would think, obviously they're a defendant. Okay, here it seemed to me a continuation of the process of trying to get his delayed birth registered, and they're not obviously a defendant.
But the district makes the argument that they have an interest in the accuracy of these records
Correct.
that are maintained by the
Correct.
registrar.
Correct.
So
Correct.
one would think that that interest should be protected in some way by ensuring that the district is present in court.
Well, their interest in proper records is, you know, if the rules are followed, the outcome is the proper outcome. And what happened is my client was born in the District of Columbia, but he didn't have the documents to prove it for reasons that were beyond his control. In that instance, he has resort to the court. He went there.
Right, but he goes to court and he's allowed to testify without cross-examination, which is usually our method for kicking the tires on credibility and ensuring that the evidence is actually reliable and trustworthy. So you just have a court taking direct testimony without a party on the other side saying, well, wait a second, you know, we've got some questions that may poke holes in this story.
Right, there's no adversary there, but the judge is there. The judge did ask some questions.
Yeah, but that's not typically the judge's role, right?
No,
We're-
it's not typical.
We don't have the continental system.
Right. But the process of applying to the government for, you know, a remedy of citizenship, birth certificates, that's not an adversarial thing in general. And to me, this is, there's prescribed requirements for having it registered. And if you can't meet those requirements, you get to bring the matter to the court to make the determination based on evidence that the register did not consider. You're not, like I said, you're not accusing the agency of misconduct, and you're not going after sanctions or money or anything else. You're seeking the result of the process that was initiated by the application to the register for delayed registration.
Thank you, counsel.
Thank you, Your Honors.
Your Honor, just a few points on rebuttal. The first is that it's undisputed that the court in this case did not provide the statutorily required notice to the registrar. It's also undisputed that the court didn't have the statutorily required background check prior to issuing its findings. And those two errors in and of themselves counsel for reversal in this case. With respect to the lack of notice, I think this case shows exactly why notice is so important. It's not an if the DC registrar doesn't have a chance to appear, it's not an adversarial proceeding, and the facts, for example, that petitioner had an Iranian birth certificate and had a previous passport that showed Iran as his place of birth, didn't surface until the Rule 60b-6 motion, where the DC registrar had an opportunity to go to court and present his evidence.
I thought the witness at the Rule 60B proceeding said that was one of the reasons that his application had been denied, although that's not actually reflected in the letter.
That's right. It wasn't reflected in the letter. But it's not one of the pieces of evidence that was available to the court because the court couldn't inquire as to the discrepancy between having a certificate of naturalization and a passport that said, that Washington, D.C. is his place of birth. And of course, the certificate of naturalization doesn't mean that he was not born in the district, but it was evidence that created doubt and then caused the registrar to investigate further, which led to a State Department investigation. The other point that I wanted to make is just that
Is there evidence of a State Department investigation? I mean, there's evidence that the registrar pass something on to the State Department, but the government's brief makes a big deal about an ongoing State Department investigation, and I couldn't find any evidence of that in the record.
You're right, Your Honor, that's not in the record. The State Department's actions with respect to that investigation happened after the appeal in this case occurred. But the registrar did testify that they had received information from the State Department that Mr. Barker had been issued 2 different passports that had different places of birth. So that part is in the record with respect to the registrar's testimony on March 21st. And the second point is, I just did want to bring up that there was no argument below that the DC Health was not entitled to participate as a party. And even now, appellant, concedes that, I mean, other than the service rules, the rules of civil procedure apply here. So I do want to take a moment just to emphasize DC Health's interest in this case. It's not simply a librarian. It's required statutorily to maintain the accuracy of the vital records. And in essence, what petitioner is seeking is an order requiring DC Health to do something, to issue a document that has this imprimatur of validity. And it is not, beyond the pale or unheard of to have a petition in order to ask, an agency to issue a document under Title 29. Corporations make filings to the mayor, and if the mayor refuses to do that, to enter the filings in the corporate record, the petitioner, the person who wants to make a filing, can bring a petition in Superior Court in order to challenge the refusal to make that filing. I'm not sure if those are civil cases. I think those might be under the APA, but those are also adversarial proceedings where the entity that refused to make the filing can go into court and present evidence as to the reasons for its rejection. So if the court has no further questions, I would urge that the court reverse, particularly because of the lack of notice to the registrar and the lack of the background check and the court's failure to consider the startling factors. Thank you.
Thank you. Thank you, counsel, for your arguments today. The case will be submitted.
Your Honor, can I just say something? about-
Counsel, the case will be submitted. Thank you very much. The next case on the calendar is 23 BG 478 N. Ray Nelson Gonzalez, bar registration number 465407. Whenever you're ready, counsel.
Good morning, Your Honors. Bill Ross on behalf of the Office of Disciplinary Counsel. I'd like to reserve 5 minutes for rebuttal if possible. Disciplinary Counsel believes that this is a relatively straightforward reciprocal discipline matter from New Jersey. We had initially requested an additional condition that Mr. Gonzalez be required to seek reinstatement in New Jersey before seeking reinstatement in this jurisdiction. That is still something the court can order, but it appears he has met that condition. We discovered that several weeks ago and filed a notice with the court. So if the court would like me to address that additional condition, I can. Otherwise, I think we're focusing on the identical reciprocal discipline, which involves a fitness requirement in this case.
You, in a few of your filings have told us that if Mr. Gonzalez was readmitted in New Jersey, that you anticipated that it would be straightforward, quick, that disciplinary counsel would conclude that it had no objection to readmission here. You didn't say you were not opposed to it, and I think you certainly had language reserving the right to act on any other information that you had. But do you have anything to report to us on that subject? I mean, can we all go home now and not have to talk about this?
That sounds great. But we don't have all that information. We haven't had an opportunity to look at a petition for reinstatement or or what was filed in New Jersey or what was found in New Jersey. All we have is the order. And that's certainly very relevant evidence that New Jersey found him fit to reinstate. But we haven't looked at that. And in prior cases, this court has said that that the decision is reserved in this jurisdiction, that the court reserves it for itself.
We have said that, and I wonder just conceptually if you can help me. Some of this touches on the issue that may be moot, but just as an original matter, you would think if you're really talking about what identical discipline is, and someone is disciplined in a different jurisdiction, and the discipline includes reinstatement in that jurisdiction. And the idea of identical discipline is we're not going to rethink things ourselves, barring exceptions. We're going to take the determination of violation that was made from the original jurisdiction and rely on it. And we're going to take the sanction that was imposed in the original jurisdiction and rely on it. We're not going to rethink any of that ourselves, barring exceptions. It seems that like identical discipline under that way of looking at things would be, and also the reinstatement in that. So the identical discipline would be you're suspended in DC until you get reinstated in the jurisdiction that disciplined you. That would seem to be like identical discipline that would be more identical and more consistent with the idea that in reciprocal discipline cases, barring unusual circumstances that meet an exception, we're not really doing our own thing. We're just taking what someone else has done. Do you disagree with that and think that that shouldn't be understood as do you have a different view of that, or am I missing something when I say it seems like that to me as an original matter?
It's very close. It's definitely a component of making sure it's an identical sanction, but I still think that, disciplinary counsel thinks that we need to look at, take our own look at whether this person should be reinstated.
And why, if we don't take our own look, barring unusual circumstances, about whether the person should be committed an infraction or should be disciplined?
Well, and we do.
No, we don't. We don't, barring an exception.
Exactly. So, sorry, that's what I'm trying to describe is we now have a procedure where reinstatement can be very streamlined compared to years ago in cases like the Willingham case, where reciprocal discipline took years itself, and then the reinstatement proceeding also took multiple layers of review.
No, I get all that, but I just here's where I'm lost as an original matter. So it's reciprocal discipline. The presumption is we're going to do exactly what they're doing. We're not going to look into it ourselves, barring an exception. I would have thought that would mean in a case that involves fitness in the reinstatement with fitness in the disciplining jurisdiction, that would mean just like we're not barring an exception, we're not going to look into whether there was an infraction, and barring an exception, we're not going to look into whether the sanction that is imposed is the right one. You would think that the same chain of reasoning would lead you to think, barring an exception, we're not going to look into whether the person should be reinstated. We'll take what they do, barring an exception. But that's not what we do, and I just am puzzled why and how that fits with the first 2/3 of how we approach it. It seems like we then take a U-turn.
I think it still fits because we look at reciprocal discipline matters and then we go through the exceptions to see what they are. I think there is a very strong presumption we're going to do the same thing. There is a very
it seems to me what we should have said as an original matter, at least arguably, I mean, would have been not to say we're going to look at it and make our own determination. It'll be streamlined. We don't do that as the first 2/3 of it. We don't say, well, we have a streamlined process for figuring out if there's reciprocal discipline, whether we're going to make the same determination about whether you committed an infraction or whether we're going to make the same determination about what the sanction is. We don't do any of that. We just say we're taking, barring an exception, that the burden is on somebody to show, whoever wants an exception. We're just going to do exactly what they did. And so I just not quite sure how it fits, but I don't want to belabor that. I do want to ask one other question, which is, so let's say I get over that, which I have to, because our cases say that's identical discipline. So, that whatever I might have thought as an original matter, that's what our case law is. So, I'm happy to live under it, but I do then have on the issue that's moot, I find it difficult to understand how it could be identical discipline to require reinstatement both places. That seems like by any measure, not identical. It's, you gotta jump through two hoops instead of one. I can sort of see, well, whose hoop you're supposed to jump through for reinstatement. Maybe it's identical enough, change it, mutatis mutandis. But I have a hard time figuring out how it could be identical discipline that you have to hop through two hoops. I can see how someone could come in and say there's an exception and you should require that in a particular case, and the burden would be on disciplinary counsel to show it. But it just in a sentence, can you try to explain to me why you think that's identical discipline?
And I think this goes to your prior question as well. Requiring reinstatement in the original jurisdiction goes to the heart of the Roundtree factors in a fitness inquiry. And to not require reinstatement in the original jurisdiction in certain types of cases, and we've laid out what examples we can think of where it applies. And in cases like this, where there's a failure to cooperate in the original jurisdiction, there's a person practicing in a distant jurisdiction where all the witnesses are far away, it might be difficult in a reinstatement case to know all of those factors.
So just it's identical discipline sometimes that depends on whether, considering all the circumstances, it makes sense to impose the requirement, and it's not identical discipline where, considering all those circumstances, it doesn't make sense to impose the requirement. That's a funny sense of what's identical to what.
It's only fair to impose it if there's a reason to.
May well be.
impose it.
I get the idea of fairness. I'm just
I
trying to figure out how
understand.
I'm trying to figure out how you think it's whether it's identical or not depends on
If
those circumstances that seem to have nothing to do with whether it's identical or not.
it also comes into play if there are conditions that maybe just, we don't know in the District of Columbia what the exact conditions the person will have to show in the original jurisdiction. So
Can I
if
ask you,
there-
is your position essentially the following, which is actually identical discipline is reinstatement in both? That's what should ordinarily be required. And there's an ability of a respondent to come in and say, well, that's ordinarily identical reciprocal discipline is both. You got to check both boxes. But if you can come in as a respondent and say, yeah, but there are exceptional circumstances why that shouldn't be required here, that would be the obligation of the respondent. Is that the position that you're taking, or is that not quite your?
Correct. They would have notice in the reciprocal discipline proceeding of what we're suggesting, and then to explain that doesn't make any sense because I have no connection with the other state. I don't think we have in the rules a strong presumption that reinstatement in the original jurisdiction satisfies the Roundtree factors, but it certainly weighs heavily on it. And if an attorney is seeking reinstatement, that's certainly some assurance, I'd say a big assurance to disciplinary counsel, and it would make it far more likely that we consent to the reinstatement and it would go through smoothly. But we still need to look at it. We still need to examine the Roundtree factors.
I have the sense, Mr. Ross, that there is at the very least some tension, if not outright conflict in some of our case law on fitness requirements. And maybe you can disavow me of that notion. So let me tell you my thinking on this. So we have cases like in re Maria Gonzalez, where we make a reference to the presumption that proof of fitness will be required as a component of identical reciprocal discipline. And then we have cases like in re Cater and Guberman. Cater says a fitness requirement is different from discipline. It is not a punishment, so to speak, for violations in the past, but it's a forward-looking kind of thing. Do we have serious doubt about whether the respondent can practice ethically? We also said in Cater that it's disciplinary counsel's burden to make a showing about that serious doubt, to show that by clear and convincing evidence. And then we said in Guberman that Cater governs in reciprocal discipline cases. And I found myself wondering, what does that mean? I do recognize I wrote the opinion in Guberman, so maybe you want to ask me what that means, but we said that in a paragraph in which we also recounted that disciplinary counsel had argued for the burden to be on the respondent to show why a fitness requirement should not be imposed. So I have thought that in light of Cater and Guberman, that disciplinary counsel has the burden as to whether a fitness requirement should be imposed. And I have thought that, as we said in Cater, it is not a matter of even though we've said that a fitness requirement may be a component of a suspension, it doesn't really seem to be the discipline itself. It's something separate. So in this case, this leads me to wonder where we are, because as I mentioned before, your filings have told us that possibly if upon reinstatement in New Jersey, reinstatement here might be a swift procedure or a fairly quick procedure, though you haven't said you don't oppose it. But what you haven't done in any of your filings is to try to show us, based on the Cater factors, that we ought to impose a fitness requirement. Now, one can certainly look at the record in New Jersey and you can point to things that at least arguably support that, but you haven't tried to make that case in what you filed with us. So that leaves me wondering whether the outcome in this case should be no fitness requirement in DC, because you haven't shown us that we should have a serious doubt about Mr. Gonzalez's ability to practice ethically. Have I misread our cases, or what's your response to what I just
don't
said?
think you've misread your cases, especially ones you may
Especially
have written.
Guberman, right?
But the fitness requirement goes to the protection of the public going forward, and that's, I think, a summary of what I heard you saying. And that's primarily why we've asked for these types of conditions. In our reciprocal statement, we didn't specifically put out a separate argument on fitness, but we've tried to point to the factors of why the fitness requirement is appropriate. This is not Mr. Gonzalez's first discipline matter for this same type of misconduct. It's not, it involved a failure to cooperate in New Jersey, which also would lead to a fitness requirement. It is a factor that would lead to a fitness requirement in this jurisdiction. Failure to supervise non-lawyer assistance, and the seriousness and ongoing nature of the misconduct would, I know that's what you're talking about, the record in New Jersey, but disciplinary counsel viewed the reciprocal matter as looking to see if an exception to reciprocal discipline applies, and the fitness requirement clearly, it's clearly within the range that would be imposed here.
And so that gets to my other point about whether it really is discipline, because I found myself wondering whether those exceptions that you apply when you're looking at the suspension, for example, or whatever the discipline, the real discipline is, whether they apply to a fitness requirement. Is a respondent entitled to or obligated to walk through that list of exceptions as to a fitness requirement? Or does that just apply to the discipline part of itself? And once again, I realize we've said that a fitness requirement might be a component of a suspension, but we took such pains in Cater to distinguish it from sort of backward-looking discipline that I wonder whether they do apply.
Understood. It is a hybrid of a sanction, but also forward-looking. And in a reciprocal matter, those are the factors that we look at. It's the exceptions to reciprocal discipline. It wouldn't necessarily make sense for disciplinary counsel to ask for substantially different discipline to impose the same thing that was imposed in the original jurisdiction. So I'm not sure how that would come into play in a reciprocal matter if there's an affirmative showing each time.
With a jurisdiction like New Jersey, I think it's agreed. I think the parties have said in their filings that, or have acknowledged in their filings that in New Jersey, where there is a suspensory sanction, the fitness requirement is automatic. It's not a matter of the court determining that there is a doubt about the ability to practice ethically in the future. You get a suspension, you have a fitness requirement. You can't practice until leave of court is granted. I wonder, given that, whether we ought to automatically assume that there is a substantial difference between if the fitness requirement is a part of discipline and it is subject to those exceptions, shouldn't we just automatically treat the New Jersey fitness requirement as substantially different because we know how it gets imposed and we know in our jurisdiction that's not how we do it?
That would be a very difficult standard, both personally for me, but also for the court, if in every case we had to fit an exact, this isn't quite fitness, but you have to show these three factors or this other thing. Disciplinary counsel looks at the reinstatement requirements in another jurisdiction, and if they look at all like fitness, we think that's the closest we can really ask the court for, rather than say, you have to look at these three factors on reinstatement. If it's something discrete like restitution, disciplinary counsel would ask for a suspension with restitution as a condition. I know there's a line of cases where we parsed this out. It was a very long time ago. And I can't remember what state it was, so it's not very helpful for me to bring it up, but that a showing of fitness in this jurisdiction is the closest we can do, and the streamlined nature of a reinstatement proceeding after the changes in 2008, whenever that was, make it easier. And I think the court would take a dim view if disciplinary counsel is not taking into account the other jurisdiction's reinstatement decision. But Gonzalez and those other cases, and it makes sense that before an attorney returns to practice, that the system should take a look at what's been done. In a case like this one, where it's been repeated misconduct, the attorney is subject to practice monitoring in the other jurisdiction, that we don't have any access to what happened in the reinstatement proceeding. We don't have access to the ongoing monitoring agreement. It makes sense that we would take a look before the attorney returns to practice in this jurisdiction.
Well, I could certainly see that as to the maybe infinite variety of conditions that could be imposed for readmission or that could accompany a suspension like a practice monitor, it would be really difficult to say those are substantially different from our own, and so we'll automatically treat them as different. But it seems a lot easier with respect to an automatic fitness requirement. So I'm not sure I'm persuaded by that argument.
Well, even if you are not persuaded, in this case, the misconduct found and the subsequent conduct found would justify a fitness requirement here.
Well, what sticks in my mind is how little you said about that in your filings. I feel like you don't have a serious doubt, maybe, just because you so often repeated about how the streamlined procedure would probably mean you wouldn't oppose it. And I'd have thought you'd have said something different if you really had that serious doubt. I get it that the New Jersey record does say something about lack of remorse and failure to cooperate and some other things that are certainly relevant factors. But there's doubt, and then there's serious doubt. I'm not sure we're there.
Well, if we look at it a different direction, in older cases like Willingham, where the whole system was different back then, but the Board on Professional Responsibility looked at the attorney's reinstatement proceeding in the other jurisdiction and said, they've met our standards. We don't need to even impose a fitness requirement here. That's not quite the situation you're talking about putting the burden on disciplinary counsel. But the court has subsequently explained in cases like Gonzalez that we don't do that because we have the streamlined procedures now. The fitness requirement in this case, I agree that wasn't, we didn't put forth an affirmative argument about it. We were focusing on including that as an identical sanction, and it cited Cater and I'm not sure what other case. I think the Pennington case for cases with similar misconduct where fitness was included. If the court advises us that we need to put forth, a better fitness argument and justify it stronger in the future, we obviously will do so, and I will try to do so after this argument for certain. But
a different question for you. The New Jersey record goes on at great length to detail the ways in which Mr. Gonzalez failed to supervise an employee and employees, but in particular his wife. And then there is a section of the disciplinary committee's findings that focuses on 3 different clients and failure to maintain communication and the other things that are described there. And I was trying to get a sense of how much the omissions, I guess, or the conduct described in those sections as to those three clients is tied to the findings about Mr. Gonzalez's reliance on his wife and her role. She, according to the facts that are set out, she had some role, at least in each of those matters. So I don't have a sense. And I guess what I'm trying to get to is that really in addition to, or is that sort of part and parcel of the first? I mean, in my mind, it arguably makes a difference as to whether this is sort of repeated conduct or conduct that should give serious doubt about ability to practice ethically in the future, or is it all tied up in this bundle of things related to reliance on employees?
I don't think we know from the record, and that's certainly something that disciplinary counsel would want to understand more in a reinstatement proceeding. But even if it was completely caused by the non-lawyer assistance, there came a time when Mr. Gonzalez knew that this was going on and took affirmative steps to allow it to continue. And these are the types of things that lead to a question of his fitness to practice. These are the types of things that we would cite in support of a fitness requirement. But we just don't know right now the answer to your question, how much was attributable to who? And it doesn't really matter. It cuts both ways, whichever way you look at it. If this was the first time that he'd been disciplined for this misconduct, maybe that would be a difference. But the findings are that he repeatedly continued to engage the same types of misconduct. And that leads to the serious doubts about his fitness going forward.
Thank you, Mr. Ross. We'll let you sit down. We'll give you a couple minutes in rebuttal.
Your Honors, good morning. I'd like to take the opportunity to thank you for the opportunity to come before you. Ordinarily, I have others come and speak on my behalf. And I thought it wise that you would like to hear from me directly as to these confusing issues that that disciplinary counsel brings before you. First and foremost, I take full responsibility for what occurred. Although, Your Honor, my wife did play a role, although it was not by my hand, but ultimately I'm the attorney. It is my responsibility. And truth be told, I've always prided myself in speaking for those who cannot speak for themselves. And in these particular three matters, I failed in that regard. If I had known that this events were going forward, I would have put a stop to them immediately. It is by virtue of these events being hidden from me that by the time that I found out about it, it was too late. That's what brought me before the disciplinary body in New Jersey, ultimately suspended. And now, thank God, I'm back. Unconditional. Although I am being supervised, but that is a blessing because I have another individual that'll say to me, you're doing this correctly. You're on the right track. Continue to do what you need to do. And that is where we are. On June 16th of last year, this court imposed a temporary suspension for my practice here in the District of Columbia. It has now been about 8 months since that suspension. I've served my 6 months in New Jersey, was reinstated. And in order to be reinstated in New Jersey, there is a voluminous motion practice that is required under Rule 1/2021 and must provide information specific to, I believe, 18 or 20 different requirements of that particular rule that must be submitted for consideration before the Office of Attorney Ethics. Clearly, that information was provided. My fitness was clearly seen as appropriate, and therefore I am back. The idea that further conditions of suspension, such as a fitness requirement here in DC. Your Honor, I agree. It is separate and apart and is actually a condition. It is an enhancement. Both mentioned in Cater and Group. So if we're going to
Just
speak.
to make sure I understand your position there, are you saying that if let's leave aside the complications that New Jersey's imposition of a fitness requirement might be automatic. So let's imagine a jurisdiction that makes a determination about fitness that's similar to our own, that's kind of case specific and requires a specific showing. And so the original discipline jurisdiction finds disciplinary infractions, imposes a sanction of some kind of suspension, and then says on a case specific basis, you need to be reinstated. You need to show fitness before you're reinstated. And then we have a reciprocal discipline matter that starts up. Are you saying that it's just not original discipline? It's not identical discipline for this court to ordinarily say, here's our identical discipline. You need to serve the suspension of the we're gonna barring an exception, we're gonna say we'll take the infractions that were found by the original discipline jurisdiction, we'll take the sanction that was imposed, and we will also impose fitness in DC. Are you saying that's not identical discipline?
Judge, if it were just the same discipline that was imposed in New Jersey.
Plus fitness in DC before end of suspension.
Then most respectfully,
You think that's not
it is not
identical discipline?
Identical to me, Your Honor, and supported by the case law is the same discipline. And therefore, if it were 6 months, it's 6 months, and that would be identical. However, here, what disciplinary counsel is seeking is, yes, impose the identical plus a fitness requirement.
Well, you say that plus, I mean, that way of looking at it reflects the idea that reinstatement is like not part of the discipline for purposes of the original jurisdiction's discipline for purposes of figuring out what's identical. And I thought we did have some cases that treat, I'm not sure I would have decided in the same way as the original matter, but I thought we had some cases that say that it is part of identical discipline for us to say for someone who has been suspended elsewhere with a fitness requirement, it is identical discipline for us to say same thing, except you have to get reinstated in DC. Who knows whether you get reinstated in the other jurisdiction, you have to be reinstated in DC. But you think that that's not our law, that it's not identical discipline?
That would not, in my argument, Judge, is that it would not be identical because the fitness requirement and supported by Cater and Gruberman, that indeed it is an enhancement. Unless disciplinary counsel is able to show by clear and convincing evidence that there is a serious doubt in order to impose a fitness requirement, then the identical discipline would be just what the originating jurisdiction provided.
Which would, in your view, include reinstatement in the original jurisdiction, but not reinstatement in DC?
Not necessarily, Judge. I would not apply for reinstatement in any jurisdiction until and unless I was reinstated in New Jersey. I think that's counterintuitive. Whether that's based on the case law or not, I believe that being reinstated in the original jurisdiction should be a given and then move forward to reinstatement in supplementary jurisdictions, which that's exactly what I did. I didn't seek reinstatement here. I was reinstated in New Jersey, which is where I live and where I practice primarily. And then once this court would impose the discipline that it deems fit, then I can move forward for reinstatement.
Counsel, can I just, touching on questions that Judge Thompson had earlier, and it's just not clear to me. Do you think a fitness requirement in New Jersey, again, assume that it's not automatic, assume that it is specific to you. Is that part of the discipline in New Jersey or not, in your view?
It is not specifically a condition, Judge, but it is incorporated in the filings that must be provided in order for the Office of Attorney Ethics to review. The Office of Attorney Ethics. in New
I think
Jersey-
you're missing my question. So just, I'm sort of merging questions from both of my colleagues. Judge
Forgive
McLeese
me,
has been
Judge.
focused on what's identical, and Judge Thompson has been focused on what's an actual sanction. And so I just want to understand your position. Are you saying that the fitness requirement in New Jersey is part of the sanction that should be considered when you're trying to figure out what's identical, or whether we should cut out the fitness requirement and just look at the term of suspension when we're figuring out what is identical discipline?
Well, Judge, unless there is a serious doubt, I think most respectfully that the fitness requirement should not be considered. And then the identical discipline in the originating jurisdiction should therefore be viewed.
Just to be very concrete, what that means, if I understand it, is, let's say in a jurisdiction that makes individualized determinations about whether to impose a fitness requirement,
Yes, sir.
and that jurisdiction suspends an attorney, finds infractions and suspends an attorney for 6 months and says, at the end, you have to prove fitness to resume practice of law. You would say identical discipline and therefore the presumptive discipline we should be applying in DC. The identical discipline would be a 6-month suspension without regard to any reinstatement fitness requirement. And if disciplinary counsel thought that there was a need for something like that in DC, disciplinary counsel would bear the burden of showing an exception to identical discipline. Is that your view?
That is correct, Judge. That is correct. And just so the court knows, I'm not opposed, and certainly I'm consenting to reciprocal discipline. I'm not invoking an exception because I don't believe there is one. I understand the reciprocal process and.
Let me just make sure about that, because one of the issues being disputed is whether imposing a fitness requirement in DC is identical discipline. If that's a legal question about what identical discipline means, if the court ends up deciding that adversely to you and says, yep, that's identical discipline, then your only way to avoid the court imposing that would be to say, yes, but that really doesn't make sense here. There's an exception. And I thought part of your brief was to argue that there were reasons why imposing reciprocal discipline, if that is part of reciprocal discipline, don't make sense because you don't have clients here and for other reasons. So
Right.
I thought you were arguing, and that you may, depending on what legal issues the court decides, you may need to be arguing that you do fit within an exception to identical discipline if fitness in DC is viewed as identical discipline.
Well, just to be clear, Judge, the reciprocal aspect of the discipline that we're speaking of is that New Jersey brought about a suspension here in DC. Everything was litigated in New Jersey. Everything was addressed in New Jersey. The issue before, I believe what we're dealing with is imposition of reciprocal and the fitness. If the court deems appropriate that a reciprocal discipline be imposed here, what I'm saying is, in the alternative, if that is indeed the case, then there should not be a separate fitness requirement. Because at the end of the day, Your Honor, my suspension in New Jersey has been completed. We can't rewrite that story. And that being the case, the reality here is we have whether there is the same type of issue here in DC. so to speak. I'm not sure if I'm making myself clear.
Well, shifting over to that, on the question of whatever the legal framework is, whether a fitness requirement is an appropriate thing to be imposed in DC, disciplinary counsel's position, I think summed up is there is a recurring problem. And this is, I think might be the fourth instance of discipline in New Jersey, at least I think that's what the New Jersey Supreme Court opinion said. There were three that related to this sequence of events that involved problems with supervision of staff. And the disciplinary counsel's take in a nutshell is there comes a time where, one time you can understand it, another time maybe you can understand it. There comes a time when it's a chronic problem where serious issues are arising because of recurring lack of supervision of staff, and that those are chronic enough and severe enough that a fitness requirement is warranted. What's your response to that way of looking at it?
Judge, I can assure you that the situation, circumstances, and events that brought about my discipline will not occur again. The individuals that I was supervising are no longer.
Well, wasn't that true after the second discipline also, and then one of the individuals was rehired?
Judge, the two disciplines were actually under the same category. They were just litigated separately. They weren't consolidated. It came out of the same process. And yes, what happened was that my wife was brought back for a short period, but only to complete forms. She wasn't doing anything else. And all that she was doing was filling out immigration documents. That's it. And translations. There was no other event, no other, she had no contact or access to files, office, and alike. The only thing that she was doing was just filling out forms. That's all it was.
What's your answer to the question I posed to Mr. Ross? We have the New Jersey record, and I guess it speaks for itself, but what would your argument point be? If the question is, did those instances of misconduct that were described in the paragraphs under the names of 3 individual clients, if we're focusing on that, were those related to the lack of supervision, or were those separate matters?
No, those are lack of supervision, Judge. Those are lack of supervision. And those matters, by the time that I had gotten to them, unfortunately, it was too late. So that was already involved in the disciplinary process. So that being the case, again, the individuals, primarily my wife, she is no longer in the office. I am it.
I asked the question in part because as to each of the clients, there is mention made of your wife and something that she did or didn't do in connection with each, but the paragraphs also mention things that you failed to do or did fail to communicate, and they don't necessarily attribute your failure to something that your wife did. So it wasn't clear to me whether the New Jersey committee or whatever it's called, sort of meant to tie those things together or not.
It was the delegation of the work, Judge, that brings about the not communicating with the client, not providing them the information, because that task, if you will, was delegated primarily to my wife. But it's on me, Judge. It's whether I can delegate, but I can't abdicate. And I understand where I went wrong, clearly. But all of these matters, the 3 matters that we're speaking, deal with actions that were done by my wife, but ultimately I'm responsible for, because it's my responsibility to follow up, my responsibility to speak to the client, my responsibility to provide the information, my responsibility to make sure that everything is moving correctly.
Mr. Gonzalez,
And that I left to someone else. Your Honor.
You are over time, so if you would like to quickly wrap up, or you can take your seat and we'll hear from.
Yes, Judge, if I may
disciplinary
just have a
counsel.
few moments.
Briefly.
Ultimately, Your Honor, I ask and I pray that any imposition of reciprocal discipline be non-proton to April 11th, 2023. I have primarily a very active immigration practice that right now is non-existent.
We understand. We've read your briefs, so
So I leave, therefore, I rely on my submissions based on that. Thank you very much.
thank you, counsel. Mr. Ross, we'll give you just a few minutes.
Just briefly, I would refer the court to disciplinary review board's opinion, which is attachment B to our reciprocal statement, starting around page 29. And I think that gets to Judge Thompson's question about what Mr. Gonzalez knew. At page 29, he knew that his wife was fabricating documents. And then the next page, he was relying on his wife and her representation that a settlement offer had been received from the other party. And then he proceeded with that settlement that turned out not to be accurate, and the clients were harmed, but it wasn't simply that Mr. Gonzalez had no idea what was happening. There had to be an understanding at that point. What's clear from what Mr. Gonzalez just stated, saying that everything was addressed in New Jersey, that may well be the case, but it's not in the record here, and disciplinary counsel has seen none of the records from the reinstatement proceeding. We've seen nothing about the indefinite practice monitoring in New Jersey that's ongoing. These things all go to the fitness requirement in this matter, and also show why reinstatement should not be automatic, because we just don't know. So if the court has no further questions, we would ask that a fitness requirement as part of identical discipline be imposed. And thank you.
Thank you, counsel. Thanks to you both for your time today. The case will be submitted. Third and last case on our calendar today is 22 FM 804 In Re TB, the District of Columbia appellant. Give counsel a few minutes to get settled, and then when you're ready, you can come to the podium.
Morning. May it please the court. Holly Johnson for the District of Columbia. I'd like to reserve 3 minutes for rebuttal. A voluntary inpatient can be emergently hospitalized if he's too dangerous to release. In this case, the Superior Court wrongly held that the 48-hour clock for that emergency hospitalization starts when a voluntary inpatient requests release, and this can't be right under the plain language of the very provision that establishes that emergency hospitalization clock. That emergency hospitalization clock starts at the time of the person's admission under section 21.522. That's the section preceding this in the emergency hospitalization subchapter. And that cannot occur before the person has been the subject of an FD-12, which is the application for emergency hospitalization.
Why can't that occur? I mean, it shouldn't, but why couldn't it? I mean, what if someone wasn't doing things the way they were supposed to be done? And so let's take the simpler situation where someone is out at liberty and is then taken into custody by an appropriate official under 521, if this is starting the process. And that person doesn't, the appropriate official doesn't do anything that the person should do, doesn't fill out the first form for admission, doesn't fill out a certification, and goes to a hospital and says, here's the person, and the hospital says, fine, here's a room, and they go off and do their thing. You're saying the person was never admitted because the legal prerequisites to admission did not happen?
I'm saying the person was not admitted under section 522.
So you think there's no clock in where people aren't complying with these requirements, no clock whatsoever says that it's illegal to retain such a person for 48 or whatever, however many hours it would be?
So I want to take a step back and talk about whether there's a clock and then whether there's an unlawful detention. Because the Irvin Act is not designed to address all sorts of instances of false arrest or false imprisonment. A hospital could falsely imprison someone, never trigger any of the provisions under the Irvin Act, and the Irvin Act just simply wouldn't come into play. But under our reading of this plain language, the 48-hour clock starts upon the time of the person's admission under section 522.
I'm startled by your answer or your assertion that the Urban Act really has nothing to do with ensuring that people have a right to liberty, that it's only assuring that if the process is followed, that the process is followed correctly. But if no one ever follows the process, the Urban Act has no application whatsoever. That surprises me. It seems like the whole point of the Urban Act was to make sure that people were not deprived of liberty unconstitutionally. And so they imposed certain statutory requirements that they thought set a due process floor. So it sounds like your answer to Judge McLeese's question is, if the legal requirements, prerequisites are not complied with, the legal clock under the statute never starts. Your answer is that's right. And all you have, I guess, is due process. Wow.
Allow me to clarify, because that
Okay.
is certainly not the position that we are taking. I just wanted to, if Judge McLeese was asking if none of these processes were followed, how would this come
Right.
into
No
play?
FD12, no 522. And then 48 hours goes by and you think nobody has a right to say, I mean, say it's 48 hours from the, well, there is no FD. Say there's no FD12, but there is a 522 certificate. Are you saying that the admission is illegal or invalid or not recognizable under the statute? And so the 48-hour provision doesn't apply? I mean, I'm very lost
I'm
as to how you see the
concerned
statute.
that we started with a hypothetical that's so broad that it's hard for me to bring it within the confines of what we're talking about, because if there's no FD12, there's no 522 certificate, there's no petition, doesn't go to the family court, and it just becomes an entirely different thing. But I understand where the court's concern is coming from, and I'd like to answer that perhaps with a somewhat more constrained hypothetical, just to give the court a sense of what we're not asking for here. Because we're certainly not asking for some unconstrained, the hospital can detain someone forever. And that's essentially not at all why we brought this appeal. What happened was the Superior Court conflated two entirely separate statutory schemes. And we brought an appeal, and in the course of looking at the plain language, it does appear that there's an unconstrained by statute, and that doesn't mean it's not constrained. It doesn't mean it's unlimited. It just means the statute is silent as to the duration of detention before the person's admission. But to the extent that this court is concerned that there's something in the statute that doesn't have a clock, the same is true of section 521.
No, I get that. And that's a fair point. And I'm interested, can you just walk me through how you think it works? Again, this case has a complication of it being a transition from voluntary hospitalization to involuntary hospitalization, which adds some complexity. But in the simpler setting where someone is out at liberty and then is brought in, just want to make sure how you think the system works in that setting. So a qualified person has to take the person into custody. And then 521 requires that the person do that and transport that person to an appropriate hospital. No time limit. So do you think the statute is silent as to how, you know, if I am the qualified person and I take someone into custody and I say I'm going to take them to the, you know, back to the police station if I'm a police officer, and they'll stay overnight and then or over the weekend, and on Monday I'll take them to the hospital. Is that lawful under the statute or not lawful, do you think?
So I think it would be not lawful under the statute, because implicit in the silence is that it has to be for the purpose,
So you say like reasonably prompt, or what would you? read in,
reasonably
or-
prompt or reasonable time. I
Oh.
mean,
I get that. So that's.
And I'd love to walk you through this if.
Well,
the court's indulgence.
so next step, then so and then you're supposed to make applications. So let's say with reasonable promptitude, the appropriate arresting official goes to the hospital and with reasonable promptitude makes an application. I'm just curious how you read the statute. While the application is being considered by the hospital for admission, as you understand it, there's time that will pass necessarily. Is it your view that the person has to remain in the custody of the qualified person? Because I don't see where the hospital has any authority to detain the person.
So I want to answer that question, but I want to start with one caveat, which is that our practice on the ground has evolved along with the Superior Court's interpretation, and some of that's clear from the briefing. And I do think that some of these processes have evolved, and I think Superior Court's interpretation has in some ways evolved along with our practice from the statute that was written 60 years ago. I don't think it would be reasonable to interpret the same person as having to retain custody until admission takes place. But I do think the detention authority until admission takes place remains under 521. It remains under that FD 12. But if you take
So
some.
just to be clear, your position is that the officer can take the person to the hospital and say, here's my application. Good luck, I'm leaving. And the hospital, you think has implicit authority under 521 to, although the person is not admitted, to refuse to permit the person to leave and hold the person in custody.
I certainly, especially so if it's the district, because any DBH hospital is going to be a qualified official under 521. And it's just as if a police officer were transferring custody to another police officer. So
That's easy in that scenario, but let's say it's a private hospital. You think the private hospital has authority under the statute to hold somebody using people who are not qualified folks who have authority to take people into custody?
I have two thoughts on that. The first is that the private hospital can refuse to accept admission. So whoever it is that's taken custody needs to make sure that the hospital is going to accept the person if they admit them.
Well,
but-
my question is, what's the status of the person while the application is pending?
I think they are detained under section 521
By whom?
by either the official that took them into custody or by some sort of transferred custody. And you'll note that under section 521, anyone who is a physician of the person, so it doesn't have to be someone who's completed a 522 certificate, has the
Understand all that.
authority.
And then, so I just to make sure I understand how you think it works. So let's say, assume for a moment that the qualified person who took the individual into custody happens to remain while the application is pending. And the hospital says, well, thank you for your application. We're really busy. We'll get to it in, tomorrow. Lawful under the statute, not lawful under the statute. Do you think there's an implicit promptitude requirement under how long the application can be pending before a decision is made to admit or not?
I think there is an implicit promptitude. How long that is, I don't think is a question this court has to answer in this case. And I will note, and this is why I included in my briefing how some other states handle this. Most states who specify an amount of time specify 24 hours for that to happen, especially if you consider that sometimes someone's coming in the middle of the night, psychiatric.
They specify by statute.
By statute,
Right.
yes.
You just said you don't think we have to answer that question in this case, and I'm kind of wondering why we have to answer any question in this case. I mean, it's moot, right? I mean, there's a question as to whether the exceptions to the mootness doctrine apply, but the argument that the district is now making that the 48-hour time, that the clock doesn't start until the 522 certificate is signed. It's not the argument that the district made below. And in fact, the district concedes that it has been looking to the signing of the FD 12 since back to Peterson. That's what I understood the district to say in its brief, that this is sort of a long-standing assumption. And there was a C. Peterson and Peterson's 2009 decision. So we're talking many years. And I'm just wondering, this just doesn't seem like the best case for the district to raise this issue, or it didn't raise it below. And then, Mr. or TB gets released and there's no seemingly there's no emergency subsequent to bring him back into custody. The district doesn't try to initiate 521 procedures at that juncture, right? That would be a great case because the district could say, well, we had to release him and then we had to start this all over again. And it was just a lot of work and a waste of everyone's time. And meanwhile, the public was in danger. And, then we brought him in, detained him on an emergency basis. That's just not this case. So I'm just sort of wondering why we should reach this issue now in this case.
So there's a lot to unpack there, and I think I have 4 responses. I'll try to be expeditious through them. First, as far as whether this falls into the exception for mootness, this is the quintessential case for the exception for mootness. It is capable of repetition while evading review. Involuntary hospitalization does occur quite frequently for voluntary inpatients, 1 or 2 times a week.
But even on those, I mean, just looking at the facts of this case, right? So if we take the trial court's understanding of the law, right, and apply them to these facts, TB requests release on June 22nd at 10 a.m. The FD, is that right? FD 12 is signed within 26 hours. And then the 522 certificate is signed the next day on June 24th at 1 p.m. And I mean, why this couldn't have been done faster? It's really not clear to me. It's just reaching back to the doctor's evaluation of TB from 2 days prior and just kind of regurgitating in a 2-paragraph, maybe 3-4 sentences. I don't understand why this is capable of or would evade review. I mean, it just seems like, well, this could be brought up, this could be raised. Like, wait a second, we've got this done, but we don't think we should have to act any faster. So tell me why this is so urgent in this case.
So it would evade review because, well, okay, I want to start by talking about the facts. None of the facts that you just referenced are actually relevant to the Superior Court's ruling. The Superior Court made a hard and fast ruling, and it's not the first time that this judge has made this ruling. So we know that this isn't specific to these facts. The judge has held that the clock starts when the person requests release. Has nothing to do with when the 522 certificate was signed. And a lot of these facts that are kind of hazy are hazy because this case came to this court before there was any probable cause hearing. It was just an ex parte petition for emergency hospitalization. So the next case, we imagine, would have the same set of facts and would involve a very similar situation in which someone was improperly released and we think they're dangerous. I'd like to respond to the rest of those points that you made, though. First of all, regarding how broad this court's ruling needs to be, I think this is important. We see, I'd say 3 possible rulings, and there's the very broad, there's the very narrow, and there's somewhere in between. The very broad is the ruling that we felt constrained to ask based on the plain language. And that's the ruling that the clock starts at the time of the person's admission and that admission can't take place until the 522 certificate is executed. That's based on the plain language. We felt constrained to bring that before this. A narrower ruling, which we don't think is justified by the plain language, we think it's atextual, but would be palatable to us, would be a ruling that the clock starts when the person is presented in the psychiatric ward after an FD-12 is executed. And that's the practice. That's the practice since before Peterson. That's how it's been for at least the last 20 years. And that we have concerns about the textual, whether the text supports that, but that certainly is something that is consistent with our practice and would not create the type of dangerous situation that is created with the clock starting when a person requests release from voluntary hospitalization. As for whether we could
And you
execute.
said there were
What's
3. I
in
think
the
I looked at-
middle?
Oh, I'm sorry.
Ruling.
Yeah, I lost the third.
So the third ruling is a possibility, but it's not one that we would recommend, which is that the court could simply hold that the Superior Court was wrong about when the clock starts and then say nothing about when the clock does start. And the biggest problem with that is that the Superior Court's test right now for when the clock starts is very confusing. Judge DeToro has held, and that this is always going to be a case-by-case question and that she'll often need to sift through the record to find out when the clock started. For her, she says it starts when the hospital first engaged with the person for purposes of facilitating admission. And so if the court looks at the Royal case, that's 2020 MHE 2411, and the Mansoray case, which is 2021 MHE 333, you can see what we've been dealing with now. And those are non-binding decisions. We now have a shift in the calendar. We have new family division judges. So we think the question, we would prefer that the question be answered either way, even if this court adopts the interpretation that is more consistent with the title of Section 523 and not the operative language.
Can I ask?
I don't want to interrupt your train of thought, but I also wanted to hear your 4 reasons. The question to you from Judge Easterly was, why should we hear this case? And you said, I have 4 reasons, and you got to number 1. Could you just list them and
Let me list
then you could go back?
Absolutely. Okay, so number 1, we think this case is not, is moot, but well within this court's discretion to hear, and we're asking this court to hear it because we're concerned about the risk of having to release somebody else improvidently before we can come again. Number 2 is the question regarding when the clock starts in our practice, like what we argued in the Superior Court. And that was what I was arguing could be the narrow ruling that we think is atextual, but that the court could still reach, which would start the clock at the time that the person is presented in the psychiatric ward after an FD12 is executed. That would be detention under 522, but not admission necessarily under the definition under 522. The third response I had was to, I guess it's kind of identical to the second one, was to proffer up this alternative ruling that is not the one we're urging under the plain text, but it does seem to be what TB is arguing 523 is meant to mean in the mine run of cases. And then the fourth is this issue about whether we have somehow waived an argument by not executing a new FD12. And I do want to respond to that, because I think that if we released TB on court order and then immediately rehospitalized him under the same set of facts, I think we would then be before this court on that question as to whether that was permissible under the Urban Act.
Can I ask you about your first point? I thought I heard you say quickly that voluntary hospitalization transforms, or there's an effort to transform it into involuntary hospitalization, not infrequently, like 1 or 2 times a week.
Mhm.
And I don't remember that in your brief. What I remember in your brief is this is not the first time that's happened, is the only thing I remember in your brief. So I guess I'm interested in the difference between what was said in your brief and what you're saying now, and what you think, to the extent that's a factual representation outside the record, how we should be taking into account on the question of whether this is an issue recurring enough to justify an exception to the mootness requirement.
And I absolutely should have started before I said those words by pointing out it is not in the record. It's not in the record. It's information that I've obtained because I thought the court would be interested in how often this comes up. So this is just my representation based on OAG's records of emergency hospitalization petitions, because that's what we have records of. We file 60 to 70 of those a week, and 1 to 2 of those every week come from someone who is a voluntary inpatient.
And there's no representation, leave aside the procedural fairness of resolving this mootness question based on representations like this. That is an interesting topic, but leaving it aside for a minute, you neither in your brief nor yet today have you made any representation about how often it's actually practically difficult to transform from one to the other under the ruling of the trial court.
So I don't have a lot of information on that. I did cite in my reply brief the Alexander case where this has occurred before. This is another ruling where we missed the deadline. But the one thing I'd like to point out is in Macklin.
And just to be clear about that, is that a case where you missed the deadline because you understood what it was and it was just impractical to meet it? Or was it one where you missed the deadline because you didn't understand it was a deadline, just like, and you don't believe it's a deadline as you don't now?
I'm not sure. I suspect it was the former. But certainly by the time this case came along, we understood what the Superior Court's ruling was. And I don't know why we missed the deadline in this case. These things happen, and that's the problem. But I do want to point out that the question of whether it's going to be a recurring problem for purposes of the mootness discretion, in Macklin, this court did not require us to show that we were repeatedly failing to satisfy the requirements of the statute. It was simply that the situation would recur.
That's very true, although in Macklin, both parties, it was kind of undisputed. Everybody wanted us to decide the case. That's not really the situation here. So our focus on whether it's appropriate to do so might be a little more focused.
Yeah, it's true. And all I can say is the situation arises often enough that mistakes, I assume, will happen. And I think this is an important thing to note. And one of the key reasons why we're so concerned about the clock starting with the request for release, the district is not notified when someone requests release from voluntary hospitalization. The district OAG is notified when an FD-12 is executed. So we at least have some control over the clock. But somebody could be in a private hospital, request release, and under the Superior Court's interpretation, the 48-hour clock, a clock designed to protect the public, would start running and we would have no control. We would have no knowledge until they asked for someone to
Do you
execute
think
an
that the
FD-12.
district would lack authority to require hospitals to provide that notice, or that hospitals would decline to provide it if the district indicated it was interested in getting it?
I think it would be an overwhelming amount of information for us to work with. Most people who request release are not dangerous. Sometimes they're ready to be released. Sometimes it's a bad idea to release them for their own therapeutic purposes. But most people go into the hospital voluntarily and leave voluntarily. And for us to have to track that just in case that might start the clock for someone being dangerous seems not at all what Congress intended. So
Can I ask you a question? You said we don't know why the deadline was missed in this case, but DBH did file a motion for reconsideration. And this was weeks after release. So there was time, right, to perhaps get some sort of affidavit to explain why the FD-12 or why the 522 certificate was signed when it was signed. I guess part of the problem is at that point, you weren't arguing that the 522 certificate was the operative time. So you didn't put in an affidavit of that sort, but in a future case, you could make this record, right? You could seek reconsideration more expeditiously, and you could actually put in some evidence about why it's so difficult to actually meet a 48-hour deadline. It seems to me that maybe the absence of a record is another reason that we would count against reviewing this case.
well, certainly what you're saying is true, that we weren't contemplating the 522 playing a critical role at that point. But leaving that aside, the Superior Court said that the clock started when the person requested release. Why we missed the deadline at that point is irrelevant, because what this court has said is that those deadlines are hard fast. It doesn't matter if we had a good reason to miss a deadline. Once we miss it, the person has
Right,
to
but
be
if you were
released.
if you were thinking, well, we want to tee this up, starting the deadline at the time of a request for a release, that's the wrong time. This judge keeps saying this, and that's the wrong time under the statute. And so we're going to make a record to show an appellate court that this is the wrong time and it's an impossible time, right? You could have that case where you got affidavits from Dr. Crawford who could say, well, yeah, I mean, I just couldn't write these 3 sentences down, within 48 hours of the request for release because I was really busy. I mean, I don't know. I don't know why it took Dr. Crawford so long to write this, but
To be clear, our argument is not that it's impossible to ever satisfy this standard. Our argument is a statutory one. Those facts are irrelevant to the statutory question. We weren't asking for an
well,
exception.
not necessarily
in this
irrelevant,
case.
right? I thought you were talking to us about in your statutory interpretation, you were saying, well, there's a 48-hour time period for releasing someone who's been voluntarily hospitalized. And then there's a 48-hour period for, holding someone who's been admitted on an emergency basis. And they're totally different things. And we've got to allocate resources in different directions. And so, sort of showing that in evidence would be helpful.
But the argument that we are making is a pure statutory language argument. TB is the one that's asking this court to deviate from the statutory language. So we have presented policy arguments to explain why it is not absurd for the statute to say what it says. But, and I have to respond to this, this suggestion that somehow we were dilatory by waiting 27 days to move for reconsideration. We were not asking for TB to be rehospitalized. We know that that's not permissible under the Irvin Act. Even if we won our motion for reconsideration, we couldn't go scoop him off the street. It would still need a new FD-12. 27 days was within the 30-day deadline, and we presented a motion for reconsideration for the same reason that we brought this appeal, because we think the Superior Court's statutory interpretation is wrong. We think that it could, in some situations, lead to very dangerous results. I don't know whether this is one of those situations. I mean, I know that he was dangerous when he was released, but I don't know if the statute under the Superior Court's interpretation somehow could have been satisfied. But that's not why we're bringing this appeal. We're bringing this appeal for a whole broad swath of future cases where we'll be constrained by a rule that could lead to these dangerous circumstances.
Did your brief cite to us cases that are examples of the Superior Court keeps doing this? That's what you've said or implied, that the Judge Totoro or whoever in the Superior Court has done this over and over. A few moments ago, you cited a couple of cases.
So
What I'm really getting to is, what are the cases we should look at to see what the Superior Court keeps doing?
those three cases I referred to would just give this court a taste of what we're dealing with if the court doesn't answer the question of when admission occurs.
That's what I'm looking for.
Those don't have to do with voluntary conversion. Those are just basically a sense of what the test is in the Superior Court for off the street for everyone. There is one other case in which the Superior Court has held that for a voluntary conversion, the clock starts when the person requests release.
I'm sorry, I apologize. Can you explain to me, answering Judge Thompson's question, you were distinguishing one group of cases and I missed the distinction. I apologize.
So let me start from the opposite side so that I answer the rest of her question and then I'll go back. The Alexander case that is cited in my brief is a case in which the Superior Court has held the same thing the court held here, that the clock starts for a voluntary inpatient at the time they request release. So that has occurred one time before that I know of. I don't know whether it's occurred other times. That's what I was able to find a record of. The three that are not in my briefs that I read into the record are simply to explain why we would prefer for the court to answer the question broadly, not just for this one
Could you
situation.
just give me the names again? I think I wasn't
Absolutely.
appreciating the point.
And actually, I only identified two of the three I've listed, and I think that's probably all you need. The first is Royal, and the docket number is 2020 MHE 2411. And the second is Mansoray, and the docket number is 2021 MHE 333.
Thank you.
And that just explains why we think the court, why we would rather the court not take an approach of just saying the Superior Court's wrong, but then not answering the ultimate
But
question.
these are not voluntary conversion
Correct.
cases.
The Alexander case is a voluntary conversion case. We don't think there should be two different rules. We don't think it makes any sense. They're two entirely different subchapters. And the clock, the clock under section 523, which is the clock that is at issue here, it's the clock that the Superior Court ruled on, specifically says that it's referring to admissions under section 522, under the emergency hospitalization subchapter.
Can I
So
say, just
sorry.
walk back? We walked through how it works in a simpler situation through 521, 522, 523. I'd like to try to quickly do the same thing, how you think it works in a setting where you're and there are really two variants of it. There's a variant where the person stays in the same hospital, and there's a variant where the person is transferred to a new hospital when it's transitioning from voluntary hospitalization to involuntary hospitalization. But just the way, let's take the situation here where the person is remaining in the same hospital, the way you think things are supposed to happen in that transition.
Okay.
I understand your position that the clock does not start simply because someone says, I'd like to be released and have a right to be released from voluntary hospitalization within 48 hours. I got that. But then how the system works thereafter, at some point people start thinking about the possibility, in some cases like this one, of trying to seek involuntary hospitalization. Because the person is already admitted and in custody in some senses of the term, there's not really a need for 521, the front end of 521, of taking somebody into custody by an appropriate official and transporting them to a place where you can make an application. So you think those, that setting, those are just sort of unnecessary, not applicable, where you are transitioning from ongoing voluntary hospitalization before the 48 hours runs.
That's
Is that
correct.
right?
Yes.
And then someone files an application. And then whatever, you think then though, whatever is normally required relative to how someone is being held or treated during the period between an application and admission, like reasonable promptitude and all that, and 521, 522, all those kick in the voluntary hospitalization setting too, or?
Yes, I think so. The delayed release for voluntary hospitalization, that authorization to hold for 48 hours under section 512, under the voluntary hospitalization subchapter. As soon as an FD12 is filed, that delayed release is over, even if only 3 hours have gone by. That's fallen away. And then the person's detention is no longer under voluntary hospitalization delayed release.
That's a little puzzling to me. Let's say that application is made and the hospital says, sorry, we're not admitting.
Oh, you were talking about staying in the same hospital, so.
Oh, I know, but I know, but so let's say that I'm the person who at issue and I voluntarily go to the hospital and I say, I'd like to be out of here in 48 hours. So that clock has started. And then the people in the hospital start thinking, I'm not so sure, maybe we should go involuntary hospitalization. And they get to the point where someone has filled out an FD12. So an application has been made to the hospital to transform my status from a voluntary admittee to someone who is appropriately held under 522. Let's say the people at the hospital say, sorry, we don't agree. Which could happen, right? I mean, it's not a rubber stamp. In theory, it could happen. What is the person that you said the clock is off, so I'm no longer a voluntary admittee as soon as it's filed. That
So-
seems murky to me about whether I'm kind of some of both or what I am.
So first of all, I don't think you're some of both. I think that somebody who executes an FD12 is either taking the person into custody or automatically leaving them in the custody of the hospital. But I'm going to note, just as a practical matter, no hospital is calling for a mobile crisis team to come do an FD12 if they don't think they're going to keep the person, because then that hospital could just do the FD12. It's only if the hospital is going to keep the person that somebody else has to, unaffiliated with the hospital, has to come complete the FD12. But
Why would
let's-
the hospital do an FD12 if they didn't think they were going to keep the person?
if
Sorry.
if they thought the person was dangerous, but they weren't going to keep him emergently hospitalized. So let's say it's a hospital that doesn't accept involuntary inpatients.
I
Um,
see. And they were going to
So,
send him off to somewhere else.
but
Okay.
if, let's say that the hospital messed up, right? Let's say that a hospital staff call for the mobile crisis team, the crisis response team to come and do the FD12. And then the administrator of the hospital is like, no, we don't have any bed space on our involuntary ward, so we're not going to take them. Well, that person is then in the custody of the person who did the crisis
I
response.
had a different hypothetical in mind where instead the administrator of the hospital looks at the application and says, you know what, I don't think this person is appropriately admitted. I know my staff thought that, but I don't, and we're not admitting the person.
Well,
What's the status of that person?
once a person is detained under an FD12, they are detained under the emergency hospitalization subchapter. So
Well, my
if,
point is, so you think that, so let's say after 1 hour, like, let's say I am a voluntary admittee and after one, and I say, I would like to be admitted, I would like to be released. So my 48-hour clock is running. And you're saying, if the hospital staff thinks actually involuntary hospitalization is a better solution and files an FD12, and it goes to the administrator and the administrator says, I don't agree, this person, we're not going to detain this person. You're saying I have to be released immediately. Even if that happens in 2 hours, so there's 45 hours left on the voluntary release clock, I've got to be released immediately because I transformed into an involuntary admittee or an involuntary applicant, or I don't know what I am exactly, but a potential involuntary admittee as soon as the FD12 was filed. I'm not quite sure I
so
see that.
the FD12 is a signed document where someone assumes custody over someone. So the qualified official is assuming custody when they execute the FD12.
I got that. My
And
question is about the
listen,
interaction between that and my, parallel status, perhaps, as opposed to obliterated status as a voluntary hospitalizee with a 48-hour clock.
I don't see a parallel status, but I have to be honest. I haven't considered this question. I haven't briefed this question. I'm probably not authorized to take a firm stance on this situation. I don't think it would ever arise. Generally speaking, once the FD12 is executed, voluntary hospitalization, even the delayed release part of it, is over. Then we are under the emergency hospitalization subchapter. And whenever this court thinks that the clock starts under the emergency hospitalization subchapter, either upon the admission or upon the detention or the admission, then that's when the
seems like
48-hour
not
clock
very
is.
helpful to your 522 argument. I'm sorry. I mean, I'm just not following. So you're saying that someone has been voluntarily admitted. They say they want to be released under 21-512. But as soon as an FD12 is signed, 512 is a nullity now, like that's out of the picture.
Mhm.
Right? And so, but you still want the 48-hour clock to start at some later point in time when the 522 certificate is signed, even though you can't contemplate that the 522 certificate would be different than the FD12 form. And this person is definitely being detained against their will, subject to the FD12.
Yes, although I'm not going to say that we can't contemplate that the 522 certificate would be different. The
I thought that's
522,
what you were saying in
No,
response
no.
to Judge McLeese's hypothetical of, wait a second, what if the 522 certifier looks at the FD12 and says, I talked to this person, they're fine. They can go.
oh, I understood Judge McLeese to be talking about I understood him to be talking about the administrator of the hospital, which is a whole different question. If someone, listen, if a doctor examines the person and finds that they are not dangerous, would the 48 hours, that I don't actually know the answer to that question. If emergency hospitalization ceases because it is unwarranted during the 48 hours of delayed release and discharge planning isn't complete and somebody doesn't have housing, I don't know the answer to that. Perhaps you would continue the 48 hours, but if the person is going to end up emergently hospitalized, which is the cases that we see, I don't see the voluntary hospitalization cases. But if the person is going to end up being emergently hospitalized, that clock cannot start before the FD12. I mean, that's the key reason we're here is the FD12 plus presentation in a psychiatric ward. Those two combined is what makes a person's detention under 522. I'm not even talking about hospitalization.
I guess I'm still sort of struggling. I mean, you say that is true, but again, going back to the facts of this case, right? A lot of the observation of TB happened before the FD12 was signed, and they were able to benefit it. And in fact, it seemed like things went pretty quickly up to a point, because they had the benefit of having interviewed, observed, interacted with TB before the FD12 was signed, right? I mean, he's there, he's on a locked ward, he's under observation. They're treating him or not treating him or unable to treat him because he's resisting treatment. So they have all this information as opposed to the person who's coming in, who hasn't been hospitalized, who they know nothing about potentially. So I'm not sure that I understand why it seems so urgent to, why we're not focusing on sort of cold, hard facts about when someone is actually at liberty and when they are not.
Because the statute is clear. And I'd like to take a moment, I know I'm over time, but I do want to walk through this statutory hierarchy because there's some important parts that I think will help you understand where we're standing with the statutory language. There's two clauses that the Superior Court had to read out of Section 523 to reach its holding. Two clauses. The first is the clause under Section 522. That's a person admitted to a hospital under Section 522. That is the clause that the Superior Court ignored that caused us to bring this appeal, because that is the clause that allowed the Superior Court to say that the person was detained in the hospital starting when they requested release from voluntary hospitalization rather than when their emergency hospitalization process began. There's a second clause, and that is the clause from the time of the person's admission. That's the one that came up in appeal. We felt compelled to press it because it is in the statutory
I get that.
language.
And I one nuance of that to just make sure I understand your position in its precise form. So one would think that ordinarily there might be a gap between the time, but again, simpler case where someone is originally at liberty and is brought in by a qualified person, not a transition from voluntary hospitalization case. Let's say that an FD12 has been filled out, an application has been made, and a certificate has been provided, and the hospital administrator is looking at it. And then a decision will be made by the hospital administrator, yes, again, or the delegee of the hospital administrator, but someone will say on behalf of the hospital, this person is now admitted. I've looked these things over, admitted. Are you saying the clock runs at the time the certificate is submitted to the hospital, or at the time the hospital looks it over and says, yes, this person is admitted? Because I wasn't so clear from your brief. At times, it seemed like you thought it was the time of the submission of the certificate to the hospital, which seems kind of countertextual if you're really focused on the plain meaning of the word admission.
So my understanding from what I know about the practice in the field is that the decision of the administrator just always comes before the 522 certificate. It'd be a provisional decision. Okay, well, if the 522, if a doctor certifies the person as dangerous enough to hold, then we will admit them. And so,
But I get that. So it may not be practical significance, but if some hospital didn't do it that way, is it your view that the plain language term of admission is when the decision is made? And a conditional one, I guess, once the condition is satisfied. But if it's not done that way, I just want to make sure I understand what you are saying the plain language dictates. Is it submission of the completed application with a certificate, or is it a decision by the hospital to admit?
I think under the plain language, all three are required.
Right.
But the hospital administrator, first of all, the district's hospitals don't get to make a decision. It's just the private hospitals. And I think it has to be all three, because let's say in your hypothetical scenario, the administrator said, oh, well, I don't care what my doctor says about the 522 certificate. I'm not admitting this person. Well, then they would need to go to a different hospital. They'd probably have to go to a public hospital, which would have to take them. And to say that the 523 clock starts when they were not admitted to the first hospital would do violence to the language. I do want to point out, though, of these two clauses, these two statutory clauses that are erased by the Superior Court's interpretation, there is some reason, and PDS has offered some reason to ignore the from the time of the person's admission clause. Now, we think it's atextual because we don't understand how that could be a drafting error. But at the very least, the title of the provision says that there's a court order requirement for hospital detention beyond 48 hours. But we don't see any reason, and TB has given no textual reason, why the words under section 21.522 would also be written out of the statute. There's no tension there with the committee report. There's no tension there with the legislative history. There's no tension there with the title. So while we're presenting the court with the fulsome statutory analysis in the way that we think is necessary, we brought this appeal to make sure that the words under section 21.522 were honored, so that the district always has notice before that clock, around the time before that clock starts ticking, so that we can make sure that a petition is timely filed. Consider a person who becomes dangerous at the end of their 48-hour delayed release. We would have no way to make sure that petition was filed. Or consider a private hospital staff just failing to do anything about it, failing to call for an FD-12. Then perhaps the FD-12 would be executed right at the end of the 48-hour period. If the clock had already run, the district would have no way to ensure the person's detention. So that's the key ruling we're looking for. This court has various options, but in its discretion, we would ask this court to hear that and at least resolve that key question. Thank you.
Thank you, Ms. Johnson.
May it please the court. Stephanie Schneider on behalf of Appellee TB. We contend that when a voluntary patient asserts his right to release within 48 hours by signing an AMA, Section 512 controls the timing of the hospital's petition for emergency detention and requires that it be filed within 48 hours of the request. Our analysis starts with 512 because the Urban Act is silent as to the intersection of the voluntary and emergency hospitalization procedures, and 512 is the narrowest provision that speaks to a voluntary patient seeking release. Its plain language is clear. Detention authority expires after 48 hours. The legislative history is clear as well. Congress foresaw the emergency situation, and the purpose of 512's 48-hour period was to enable the hospital to file an emergency petition where warranted, just as 523 authorizes 48 hours to file a petition for off-the-street emergency patients. The government has no textual or historical support for its claim that Congress intended hospitals to have authority to detain voluntary patients 48 hours longer than off-the-street patients by stacking 512 and 523's 48-hour periods. And it's contrary to Congress's overarching goal of incentivizing voluntary hospitalization by reducing barriers to release. And I want to note that, Peterson, recognized an exception to release, finding that the Irvin Act did not preclude emergency detention of voluntary patients in extreme cases, but it did not grapple with the process or the timeline for detaining a voluntary patient prior to judicial review. And this is where we, when we look at the text, we see that the emergency procedures in 521, 522, and 523, which talk about taking a person into custody, transporting him, admitting him, they don't map on neatly to a patient like TB who has already been admitted to PIW, is in a locked ward, receiving ongoing evaluation, diagnosis, and treatment. And this lack of
Well, they
fit
couldn't
creates-
they? I mean, if people were really concerned about making sure every I was dotted and T was crossed about how you do things on the emergency side, someone who was a voluntary admittee who had indicated a desire to be released could like literally, they could bring in a qualified person and say, you are in my custody. And then they could do, transport you to the front desk of the facility, and they could do everything exactly as is contemplated. There's nothing intrinsic in status as a voluntary admittee that would preclude literally checking off every one of those boxes, is there?
Yeah, no, sir. I mean, certainly you can try to make it fit. I think our point is, that these procedures, I think it's fair to say were drafted with the prototypical situation in mind, where someone is taken into custody in the community, and transported to a hospital for hospitalization. And we acknowledge that conversion can happen. But I think my point is that sort of this misfit between how these procedures intersect, it creates ambiguity as to how they apply. And I think it's that ambiguity that requires this court to do a more holistic review of the legislative history and the statutory scheme to discern what was Congress's intent in this situation. And at the end of the day, that is the ultimate question in statutory interpretation. And I think, if you look at the legislative history, it is clear that the purpose of that 48-hour periods was for an emergency petition where warranted. Senator Irvin, the sponsor of the bill, said it explicitly. The committee reports also reflect that Congress anticipated the occasional emergency, but they chose not to write in an exception to release for fear of deterring voluntary patients. One of the goals was to incentivize voluntary hospitalization. These 48 hours, however, they provided a safety valve for the emergency scenario by allowing time if it arose. And in our view, it is no coincidence that 512's 48-hour period is identical to 523's 48-hour maximum detention. 48.
So that works well in this case, right? Where pretty much at the same time TB is asking to be released, saying I'm ready to go. People in the hospital think this person shouldn't be released. We think that he's a danger to himself or others, right? And so I think they immediately request the community response team, although they don't show up immediately, right?
That's right.
But what about the scenario that the government posits where, the person says, I'm ready to go, and 36 hours later, they start to, I was going to say decompose. That is not the word I'm looking for. They start their mental health suffers drastically. What about that scenario, and how do you think the statutes should work together in that scenario?
I mean, our understanding is that the 48-hour, the purpose of that, that limited 48-hour period is because Congress thought that was enough time. Could a patient decompensate at the very end? Sure.
Compensate.
But
That's the word.
But that's the case. I mean, that's also the case in the, for the off the street patient. Somebody could have been brought in off the street. Initially the thought was, mental illness, and then a determination is made. Oh, actually, we just think it was, from drugs, not mental illness at all. And then at hour 36, a different opinion is formed and they're going to have to scramble. I mean, I think obviously that can happen under either scenario, but we think Congress was purposeful in picking 48 hours. I think we have to remember this is a statute that is focused on liberty interests. Like the overriding goal of Congress was to provide for the constitutional and civil rights of people experiencing mental illness. And for that reason, it has these strict and precisely circumscribed timelines that are the core of the act. And
Can I
can we
ask you, I'm back to, if people were trying to really ride both processes in great detail, how you think this should work. So let's imagine that what had happened in this case was, or in a case similar to this, someone was originally a voluntary admittee, made a request, and let's say after 12 hours, a qualified official came and said, "I'm taking you into custody. The hospital is releasing you from voluntary," like the hospital issues an order, cutting you a release order saying you are released from voluntary hospitalization. We met the 48-hour requirement. Voluntary hospitalization is over and done, and that clock was satisfied. Are you saying that? And so then people start the involuntary hospitalization by either to a different facility or to, the front desk of the same facility. A qualified person who has taken the person into custody says, "Here's my FD-12 application," and then the whole process gears up. Are you saying that although the person has actually been released formally by an order of the hospital from voluntary hospitalization, you just can't convert them in that way, and they're still treated as voluntary hospitalees with a clock that no one can stop running and must be, at some point you can convert them, but only, I guess, at the very end of the process? Or how do you conceptualize that?
I mean, if I'm understanding the hypothetical, I mean, I think our position is that when a voluntary patient seeks release, the maximum amount of time they can be detained by a hospital after that point is 48 hours unless a petition is filed. And I want to emphasize the importance of the petition. The reason the petition matters.
Well, but the reason I just to interrupt, in the hypothetical I gave, the person is, at least for some of that period, a little bit depends on the answers to these questions of the status of people while applications are pending and after FD-12 has been filed. That person is not in the custody of the hospital. That person is in the custody, and the hypothetical I was giving, as of the moment of the hospital says, "You are no longer in this hospital as a voluntary admittee. We release you." So that person is in the custody of the qualified official at that point. So if there is a clock that says you can only be in the hospital for 48 consecutive hours or whatever, that's no longer the case in the hypothetical because the hospital has released the person.
But I guess if I understand your hypothetical, released to another form of detention. I mean, I
But
think
not by the hospital.
not by the
qualified
hospital,
official.
by another qualified official who is going to take the person to yet another hospital
Or
for
the same.
additional, presumably detention. I mean, I think the focus, I mean, we got to look at what the focus of Congress was, and it is concerned about this detention of people with mental illness, and it is trying to make that shorter to encourage voluntary hospitalization. I want to flag that under the old regime, prior to the Irvin Act, it was 72 hours. It was a 72-hour release period. They made that shorter to 48 hours. They are trying to reduce barriers because what they heard at the testimony was expert after expert came in and said to Congress, voluntary hospitalization is the most therapeutically sound way to treat patients. It's the best in all respects. And people are not showing up voluntarily because they are afraid they won't be released. And that is the problem. I think Congress was very responsive to that by trying to reduce these barriers and trying to put them, at least on equal footing with their counterparts in the community who are taken into custody in the street. A voluntary patient should not be in a worse position with less liberty than somebody who never seeks that care in the first instance and is, taken into custody in the community. And I think that is what's animating.
It's not clear why in Judge McLeese's hypothetical, though, the voluntary patient would be in a worse position. I mean, let's change the hypothetical a little bit. So the request for release from voluntary hospitalization is filed and the hospital does its discharge planning and whatever it's doing. And the patient actually steps outside the hospital only to find the person holding the FD-12 who then says, "You're in my custody. I'm now taking you to a hospital." Because I understand that in the, I saw you through the window and I saw you acting out in there, and clearly you're out of control, you're decompensating, you're a danger to yourself or others. I mean, that person is in precisely the same situation as a person off the street. I mean, it seems to me Congress accomplished what it wanted through the shorter time. Why do we have to tie the hands of officials who can take people into custody by saying that my twist on the hypothetical doesn't allow a new 48 period to start running, or because it's not really different from Judge McLeese's, that his hypothetical doesn't allow another 48-hour period to start running.
I mean, I guess in your hypothetical, if the person has left the hospital, they're out in the community and there's new behavior, new actions that give rise to a qualified individual, taking that person into custody, that might be a different situation.
But
But I don't
think that
think
was
this,
hypothetical, though. I think
but I don't-
the hypothetical, I don't mean to, but or at least the hypothetical or a variant of it I'm interested in is imagine that in response to a ruling favorable to your position in this case, the district took the practice of saying, okay, here's our plan. When we have someone who we think is an appropriate involuntary hospitalization patient who makes is involuntary hospitalization, makes a request, we're going to do the whole 48 hours. We will release the person at, hour 47 and a half, and we'll have somebody standing right outside the hospital based on the information that we already had, not anything new.
Mhm.
And we will apprehend the person, take them into custody, and immediately take them to a hospital. Would that be, in your view, that I assume in your view, a new 48-hour clock starts, or maybe you think there's kind of some sort of although there's a break in hospitalization, and the person actually was released, there's a sham exception, or how would you think that would function?
I mean, it does feel like that is trying to very clearly circumvent Congress's intent. I mean, particularly with the hypothetical where there's this coordination. I mean, it sounds like in all of these hypotheticals, maybe except the looking through the window one, that there's sort of been coordination by the hospital that's detaining a person, coordination with another entity to get around deadlines. I mean, to us, that seems that is circumventing the statutory scheme and the intent of the Urban Act. Again, if there's wholly new behavior, somebody leaves the hospital, is released, and there's wholly new, new grounds, that's a different situation. But this sort of coordination between a releasing hospital to run the timeline just for the purpose of starting a new timeline.
What if it's not coordinated? I mean, what if there is the scenario where the one that you posited, where initially there's perceived to be some sort of mental health issue, then they think, actually we think, he was just under the influence of something, and then some psychosis develops at hour, 40. And they do scramble in their, good faith efforts, and they try and they can't get everything done until hour, 48 and 5 minutes. So patient walks out of the hospital and then they finally get everything together, right? And what about that scenario? Are you saying that with that break, the new clock under 521 wouldn't start?
This is a hypothetical where it's a voluntary person, a voluntary patient.
The voluntary admittee
Mhm.
who seeks release serves out their 48 hours, but during that time, the hospital thinks, oh no, this person should be detained on an emergency basis. But they are not able, despite their best good faith efforts, to get everything done.
I mean, we think that these time limits are firm. That's the reason why this court's case law has held, that the 24 hours for a probable.
But which time limits, right? Like the 512 time limit would be honored.
Mhm.
The patient would be released. But then 5 minutes later, because that's when they finally are able to get the paperwork done, the 523 timeline starts.
So our view is that in the voluntary case, the 48 hours set by 512, the purpose of those 48 hours is for emergency petition if necessary, or release. And it's sort of an either or. You've got these 40 hours, and at the end of the 48 hours, either the person is released or an emergency petition has to be filed. Like that's our understanding of what the purpose of 512's 48 hours is, and it puts a person on equal footing with someone in the community. Now, if something happens at the very last minute and they miss the deadline, I mean, our view is that that's a strict deadline. I mean, this happens. I mean, this court has held that in the context of somebody, requesting a probable cause hearing, if that happens late, the person is released, even though there's already been a finding of dangerousness, a judicial order finding it. These timelines are strict, and that's because of how essential these timelines
But we
were.
said in Peterson that they're not, in 21.512 could be viewed as an absolute strict requirement. And I mean, the argument was made in Peterson or Pedersen, however you pronounce it, that really because of the idea that you don't want to deter people from voluntarily going to the hospital, you should just never allow voluntary hospitalization to morph into involuntary hospitalization. And we said no to that. So it's not the case that no matter what has happened, if someone starts as a voluntary admittee and makes a request, that at the end of those 48 hours, no matter what has happened, they can't be in hospital custody. We know that from Peterson. The question, and take that as a very strict deadline. The question is, I think your submission is, Pedersen is a narrow exception where you've gotten all the way to a complete petition. It doesn't really authorize any further extension or hospital detention if you're earlier than that. And that's really, in some ways, kind of a view about the scope of Peterson and not a view about how to interpret in the ordinary case the language of 521, 522, and 523. Am I right in understanding that?
Well,
as an
it's
aspect of
both. I
argument?
mean, it's a view about the scope of Peterson, but also our reason for thinking that those 48 hours are strict and the petition has to be filed during that time period is informed by our review of the legislative history and what you see in the Senate reports and the House reports is Congress contemplated that there would be an emergency situation. They don't write in an exception because they don't want to deter it, but they contemplate that it might happen. And what Senator Ervin said is he said the purpose of these 48 hours, he said, is to allow and I'm going to quote here, he says, I think that would allow enough time for the hospital authorities to institute involuntary hospital proceedings if necessary. There's always a danger of the court saying that the expression of one thing is the exclusion of another, and immediate release might be an implied exclusion of further necessary action by the hospital administrators. And I read that in conjunction with the committee reports, in conjunction with the selection of 48 hours, which is the same time frame for 523, to mean that they are putting in that 48 hour period for the purpose of making an assessment on whether or not somebody is dangerous to release. And I think you've got to read that 48-hour release period. It has to be understood in light of the constitutional backdrop right against which Congress was legislating and its overarching purpose to secure the constitutional rights of the mentally ill. Like ordinarily, for involuntary detention, to be constitutional, there have to be some sort of concerns about dangerousness that are motivating it. We submit that's what these 48 hours were for in 512. They're a safety valve so that courts wouldn't conclude that it's absolute. There is an exception, but that's what they're for. It's the same 48 hours as in 523 for the off the street person. Hospitals shouldn't be able to detain the voluntary patient for substantially longer than the off the street patient.
If you're right on the merits and this liberty interest is as you describe it, why shouldn't we hear this case and establish that? What's missing from the record, or what's the reason why we shouldn't exercise our discretion to hear this case and declare the law to be what you say it is, or to be what your opponent says it is?
And referring to our mootness argument, I mean, I think we recognize that this court has discretion to consider this moot appeal. But we do think that because it is moot, that this court does need to rule narrowly and decide only the question presented, which here that question is the timeline for an emergency petition where a voluntary patient asserts his right to release pursuant to 512. And we think the court can answer that by 512. I know there's been a lot of discussion about all sorts of hypotheticals in different contexts that haven't really been fleshed out or fully briefed. And we don't think that the court should issue a big, sweeping opinion. But we recognize that given all the briefing that's gone into the facts that are presented here and the case that's presented here, this court may want to exercise its discretion to decide this narrow issue. And we think that 512 controls this issue, and that there's serious problems with the interpretation advocated, by the government, in terms of 523 and this indefinite period of detention. I mean, we don't think the court needs to resolve that because 512 answers the question here.
Thank you, counsel.
Thank you.
So I want to start by talking about ambiguity, because I think that before this court gets into what makes sense and what's a good policy question, what the legislative history says, first you have to look at whether the statute's ambiguous. What we have here are two entirely different statutory schemes, and they don't address each other, and each one gives separate detention authority for different purposes. I don't see
I feel like I've
ambiguity in
seen
the
this
two.
movie before.
Perhaps, but I'm going to move on because immediately from that, I'm going to go to the legislative history, and I'm not repeating what we were discussing in the opening part. I apologize for that. Because I think it's important to know that there was a lot of conversation over days and days of congressional hearings about how long each of these separate deadlines should be. How long should the delayed release from voluntary be? How long should the emergency hospitalization clock run? And not once did anyone say they need to match so they can run concurrently. This idea that it was on purpose that they're both 48 hours and therefore they must run concurrently is not in the legislative history. And while they're having all of the policy discussions about how long each of these periods of detention should last, you'd think if they were meant to run concurrently, they would. Now, opposing counsel just referenced the legislative history suggesting that voluntary inpatients need to be on equal footing with off-the-street emergency hospitalized patients. Nothing in the legislative history suggests that. And we offered evidence to this court of other states that indeed do stack these detention times for voluntary inpatients, or two states that actually have entirely different schemes for voluntary inpatients that are too dangerous to release, which greatly increase the amount of time that they can be held. Now, we're not
But
suggesting—
those are clearly spelled out in the statute. I mean, I'm trying to understand what force at all the government thinks 21.512 has.
So 21.512 authorizes hospitals to hold someone for 48 hours after they request release. And if nothing else happens within that period of time, if there's no other detention authority, they have to be released. But if a police officer came to arrest someone for committing a crime within that time, no one would say, well, 512 says you have to be
Weird way to
released.
say 512 authorizes hospitals to do something. It seems like it's a command, right? That within 48 hours of the receipt of the request for release, the hospital shall release the person.
Well,
It's
implicit in a within a certain amount of time you shall release is within that period of time, you don't have to release.
Sure, but the end game is you have to let this person go.
Well,
So
but
I'm trying to
this-
figure out what force that directive of you have to let this person go has in the government's conception of this statutory scheme, reading these two statutes together.
Well, this court answered that question in Peterson. This court said in Peterson that you have to let the person go does not apply when emergency hospitalization petition, when the FD-12 is filed. That plain language interpretation of 512 is off the table at this point. And so, and I also want to—
Peterson didn't decide that question. I mean, that is what happened in
No,
the case, but
I apologize, I didn't mean to interrupt. Peterson absolutely decided that question. Peterson, it said, it acknowledged that there was tension between the plain language of 512 and the emergency hospitalization process. And it said, despite that tension, we hold that within, and I apologize, I don't have the exact language in front of me, but it said that despite that, emergency hospitalization essentially trumps that you don't have to
No,
release the person.
I apologize. Maybe I thought I heard you say something about an FD-12, but for sure you can you can hospitalize someone on an emergency basis. You can convert someone. That's what Peterson says.
So that means that you don't have to release them within 48 hours. I mean, that's relying on just the plain language of 512. It seems very strange here when this court has already held that section 521 and on at SEC, the emergency hospitalization subchapter, essentially trump that right to release. And I want to address what Senator Ervin said, because I think that this does matter. Senator Ervin said that he thought that that would give the hospital adequate time, or government officials adequate time to initiate emergency hospitalization proceedings. We don't know what he meant by that. Did he mean petition the court, or did he mean emergency hospitalization proceedings as in start with the FD-12? So I don't think that plays in our favor. I don't think it plays in TB's favor. I think that the legislative history offers very little guidance as to what was meant here. Certainly the legislative history does not suggest that Congress elevated an individual's liberty above all other concerns. In fact, it didn't even elevate that. It didn't even promote voluntary hospitalization to the full extent that it could. There were witnesses who asked Congress to say, hey, if someone goes into the hospital voluntarily, they can leave whenever they want. And Congress said, no, we're going to allow for a 48-hour hold. There were people who wanted a shorter period of emergency hospitalization. And Congress said, no.
The fact of the matter is that you're putting people who seek help voluntarily in a worse position than if they hadn't sought treatment. I mean, I don't understand that.
I want to push back against worse position, because I understand, of course, the public defender service's job is to protect their liberty. But TB is a good example. TB was suicidal. He was actively suicidal, and he voluntarily sought help for that. And then he decompensated, and then he demanded release. But to suggest that he's in worse footing because the government was constrained to a certain amount of time, it isn't necessarily fair. We think the scheme contemplates the possibility.
But I mean, you say he decompensated, an FD-12 was submitted, a 522 certificate was submitted, but late. And then he was released, and there was no effort. I mean, there's no effort to take him back into custody. There was no effort to hospitalize him on an emergency basis afterwards. So, but had the government's efforts succeeded, he would have remained hospitalized involuntarily for an extended period of time. I mean,
not an extended period of time. He would have been entitled to a probable cause hearing within
well,
24
more
hours.
than the 48 hours under 512.
I'm sorry.
More than the 48 hours under 512.
Yes, that absolutely can happen. And we contend that that's what Congress intended. We think that's clear from the plain language. But I also want to point out that what opposing counsel talked about with regard to what would happen if we released him and immediately tried to rehospitalize him, as you just suggested, is exactly the situation we would be in. If we had said, no, Your Honor, we think this person is dangerous, and so we're going to release him, but then immediately rehospitalize him, his attorneys would have gone to the Superior Court and said there was no new dangerous activity. Doesn't matter that he was saying he was going to kill people within the last 24 hours. That's not new enough. And then we'd be in court again over whether there was a sham release. Now, Peterson, one of the key things that Peterson held is that it's not good for the patient to release them and then pick them up again. And this court didn't reach the question in Peterson about whether that would even be lawful under the Ervin Act. But I don't think there was anything untoward about the district accepting the Superior Court's holding, releasing TB, and not trying to immediately rehospitalize him. That's what we have been told is how we are supposed to comply with the statute.
You read to us a few moments ago some language from Senator Ervin about emergency procedures during the 48 hours. Your brief makes a point of saying that the purpose of the 48 hours is for discharge planning. Remind me, please, of where you get that language from, the discharge planning.
The discharge planning comes from a later enacted version of the statute. And I want to make clear, because we're starting from a plain language point of view, we're not trying to suggest that Congress, when they first enacted the 48-hour hold, was planning for that to be for discharge planning. They might have been. They also might have been planning for it to be for a cooling off period, as we also suggest. Legislative history is silent on that. But that is certainly what that time is used for now as a matter of law. And that discharge planning is quite complex. Frequently, we have to find people housing. Certainly in TB's case, that would have been helpful, as he remains, as far as I know, still without a fixed residence. And so they have to find housing for them. Often they have to connect them with outpatient patient service providers, I'm speaking too quickly. Often they have to connect them to other agencies like Child and Family Services Agency or the Department of Disability Services. They have to connect with their family and they need the patient to cooperate as well. So that time period, I mean, it could go smoothly. I'm sure some people are released much earlier than the 48-hour hold, but that is one of the purposes of that hold. And we do think that if emergency hospitalization has to start right away, those purposes will be undermined. And that's everything I was asking to address. Thank you.
Thank you very much, counsel, and the case will be submitted.
All rise. This honorable court is now adjourned.